Yes, sir.
May it please your lordship?
Yes, yes.
My lord, subject to the convenience of your lordship, my lord, may I seek permission to move an unlisted writ petition. My lord.
Tomorrow.
My lord, kindly, my lord.
Where is the urgency?
My lord, this is, they have terminated my tender, my lord, and they are about to take coercive actions, my lord.
Tomorrow. Sir, tomorrow.
May I, your lordship?
Yes.
Your lordship, I beg to mention item number 42, your lordship.
42.
Yes, sir. This matter may be listed after 4 weeks, your lordship.
No. This is 2018 matter.
Yes, sir.
We'll take up today.
in
Who is
this
for the petitioner? Anybody?
Yes, we have taken
Huh?
concern, your lordship. In this
Huh?
matter, additional senior government advocate, G. is appearing. He's not present today, your lordship.
We'll do an alternative. We'll take up it after 2018 matter. What is the matter?
Service matter, your lordship.
What service matter?
Actually, your lordship, I have never gone through
You
this.
have appointed a person who has got a lesser mark in the written examination.
Actually, this matter was handled by
And that's the
Dr.
reason
He instructed
you had not the furnishing the answer script to the petitioner. We'll take up it afternoon. Ask somebody to go through the file. We'll see
GFS.
afternoon at 2.
Your Lordship, I like to mention item number 36.
36.
Yes. Senior counsel is out of station.
Your
A.
name,
Rai.
please.
A. Rai.
Huh?
A. Rai. Aruna Rai.
You are here in this matter.
Yes, Your Honor.
Your name is there.
Yes,
You said
Your
the
Honor.
power.
Yes.
MS. It's not there.
Aruna Rai.
Okay. A. Rai. Learned Council.
Your Honor, list this matter on 1st of April.
Press for listing the matter after 2 weeks. Press there. List this matter after 2 weeks.
Much obliged.
My lordship, with concern from other parties, I beg to mention item number 18.
18.
Kindly this matter may fix after 1 week.
On the prayer of you are for
Respondent number 3 and 4.
on the prayer of Mr. Swain
And father, on behalf of and
Council
father.
appearing on behalf of respondent 3 and 4. List this matter after 2 weeks.
Kindly 1 week.
Huh?
Kindly 1 week.
After 1 week.
Deeply.
Mr. Tara, are you appearing item 18?
Yes.
No objection.
No, okay.
Okay.
Highly apologize, Your Honor. Item number 18. The interim is there. That may be continued.
Okay. Interim order.
Interim order is
any,
there. I'm a petitioner.
Shall continue.
A short that may be given, Your Honor, since it's
After 1 week. After a week.
After a week. Much obliged.
Your lordship, I beg to mention item number 42.
42.
On behalf of Subhu Koyam.
42.
Yes, your lordship.
No, we'll take it up at 2.
Your lordship,
We'll see.
the
You go
learned
to the-
counsel
you
is
take
out
the
of
se-
station.
You take the second file and we'll see. Yes, anybody else?
Your Lordship, I beg to mention item number 24.
24.
Concerned counsel is from Guwahati, so
On the
he,
prayer of Mr.
due to some
So and
difficulties.
so learned counsel appearing on behalf of Mr.
the-
S. Chaudhary.
yes, sir. Fixed on, sir, 4 April.
Press for listing the matter after a week. Mr.
After a week, sir.
Praise the Lord. List this matter after a week.
May I, your lordship? Your lordship, I beg to mention item 21 and 22 on behalf of Taja Garam. The learned conducting council is out of station, your lordship. Therefore, it
Item
may-
21, 22.
22,
On the
yes.
prayer of learned counsel to the
Maybe fixed on
petitioner, list this
30th
matter
of this
after
month.
4 weeks. Huh?
30th of this month, if possible.
Why 30th?
I was instructed.
This is a holiday. 30. 30.
Yes, Your Lordship.
It's holiday, Saturday,
Saturday. Then after 1 week.
after a week.
And Your Lordship, I beg to mention item number 31 and 33 as well.
31 and 30.
On behalf of conducting council Titagu,
31 and 32.
33.
33, huh? On the prayer of learned council for the petition.
This matter may be
after
fixed
2 weeks.
April 2nd or 3rd
After a week. Huh?
after a week. And lastly, Your Lordship, I beg to mention one unlisted matter.
Tomorrow. What is the urgency?
It's a criminal petition. Lordship.
Tomorrow. Or on first week.
Much obliged.
First week. After a week.
Much obliged.
My lord, I'm here on behalf of Bintar Picha. I beg to mention item number 37 and 38.
37.
The leading counsel is out of station.
On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. B.
Your Honor.
Learned counsel for the petition. List this matter.
Matter may be
after-
fixed on 1st April. Your Honor.
After a week.
Much obliged. Your Lordship, this is a petitions for payroll.
Yes.
My only prayer is that either my father should be taken for treatment for operation as directed by the board of doctors, or he should be released on
For
bail
surgery.
for surgery.
Surgery. Huh?
Lordship, last time we have placed the record and thereafter,
Thereafter,
again,
there is an order.
we even sent through this WhatsApp and all, but we have no instruction. Lordship,
But
it's up
they
to
have
your
not taken me. They have
Huh?
not taken my father for surgery.
Huh?
Because he is serious. Either within a week, a direction maybe should within a week he should be taken to the AMC for surgery, or he should be released on payroll so that we can.
No, just you have you seen the last order, sir?
Lordship, I have seen, we have, accordingly, we have acted also,
Huh?
but we have no instruction till now.
No, it's not question of not acting or not acting or not acting. 2003.
Lordship,
Huh?
we have that order.
You just take the over the telephone. I mean, telephonically, you take the instruction right now. We'll take about 2. What's there? What steps you have taken now? Because there's a advice for surgery. You just ask that.
Lordship, yes,
At
well,
2. We'll call for the city.
Yes, Lordship.
Appears to be your involved,
No,
right?
Lordship, I have interim prayer also.
Huh?
Lordship, interim.
No,
prayer
no,
also.
no interim. You appears to be you know the account number, you are the manager, and you know that person, Sekia,
Yes, Lordship.
Felipe Sekia. There appears to be your involved. No interim.
All right.
All right.
All right.
Who appears PP? Heard Mr. So-and-so, learned counsel for the petition. Applicant.
Your Lordship,
We'll call
I'm-
for the city.
yes, Your Lordship.
No interim. He appears to be involved.
Yes, Your Lordship.
This is an application under section 438 of CRPC, 1974. Praying for privilege of pre-arrest bail to the accused applicant in connection with Chimpu PS case number 13 of 2024 under section 120 within bracket B, 419, 420, 460, 471, 379, the 34 of IPC. Comment 1860. Call for the case diary.
Lordship,
MS.
fixing the matter on 4th of April. Lordship.
MS Tijin Leonard. Additional PP appears for the state list on
Twen-
04/04/2020.
Yes. The
This side or this side?
Balance 15%.
My lord, as per the earlier order, my lord, we have taken the justice service upon the
Yes.
private responder, my lord.
So-
It's been done. It's been completed, my lord.
Hmm.
My lord,
Yes,
my lord, my case is, my lord, NIT, my lord, NIT was plotted on 29 January 2024, my lord. Wherein, my lord, there's a specific provision, my lord, criteria at page 43. It's start from page 42 and relevant para is page 43, my lord.
yes.
Page 43, clause 7, my lord.
Hmm.
Contractor who fulfills the following initial requirements shall only be eligible to apply. Number one, A, my lord, should have completed 3 civil works, each of 40%, or 2 civil work, each of value 60%, or 1 civil work of value 80% during last 5 years, my lord. This is the first eligibility criteria.
Hmm.
On fulfillment of this only, it can apply, my lord, participate, my lord.
Hmm.
Here, my lord, now apart from that, my lord, this criteria has not been fulfilled, my lord. This same provision, it has been reiterated, my lord, at ITB also, my lord. ITB clause 4.5, page 56, my lord.
Either three civil works, each of value for 40%,
Yes, my lord. That is,
or 2 civil works of 60%, or 1 of 80% during last 5 years.
yes.
Either of the 3.
In case, yes, in case of, if it is 40%, then this should be a 3 completion experience report, my lord, certificate. In respect of 40% and 60%, 2 completion certificate.
Yes.
In case of 80, my lord, only 1, my lord. Now, that part has not been complied with, my lord,
Complied by whom?
by the private respondent, my lord.
Okay.
It's not, it does not even meet the eligibility criteria as per.
Forget about the respondent number 4. Why you have been rejected? You start from your case.
Yes, my lord,
We'll come to the.
my lord, that's why my case has been rejected arbitrarily. My lord, I see, my lord, I'm L1, my lord.
Hmm.
L1, my lord, see at my lord, it was first,
Why you have been rejected? Why your tender has been rejected? That's you tell us.
my lord, that is not specific. That is why I might challenge, my lord. This is single bid system, my lord. This is single bid, that this was open simultaneously, both technical bid and it is one go. It was on page 73, my lord, for timing, and see page 73, my lord.
7-3.
Yes. Page 73, this, the bid was opened on 5th February 2024, man. And the result there was notified on 6th February, man.
Yes.
Now here,
Hmm.
all these, the all participant firm, they have been admitted, my lord. Now, the result of this bid was opened, this was published at page 74, my lord, see, page 74.
Hmm.
It was published, we'll see at top, e-procurement system government ordinance. It is auto-generated, my lord. Created times also 13 February 2024.
Yes.
It was notified on 13 February, and at page 122, I was adjudged as lowest bidder. Page 122,
Yes.
lowest bidder, and at page,
122. Where it is?
my lord, 122, lowest bid amount quoted by MSDD Enterprises Fund. I'm the lowest bidder.
Hmm.
And next page, at page 123, summary report. It was summary of the BOQs there.
Hmm.
DDG Enterprise L1, NGP L2, my lord.
Hmm.
Now, despite of notifying this, my lord, my at page 139,
Hmm.
139, my lord, see. One title. This is the impugn, my lord. Closure reports. E10
Due
also,
to submission of unsatisfactory justification quoted rates, huh? Yes, reason is given.
my lord, there's no ground for rejection of this. My lord, under SBD also, my lord, the L1 has to be awarded. My lord, it is specifically there at the SBD itself. My lord, you see at page 66. Page 66. It starts from page 51 to 72. Now relevant page is page 66 of SBD.
Yes.
My lord, page 66, my lord, see at page close 1.31.1.
Subject to clause, blah, blah, blah.
Subject to clause 32. The employer will award a contract to the bidder whose bid has been determined. One, my lord, to be substantially responsive bidding document and who have offered the lowest evaluated bid price. Now,
What do you mean by the second one? Roman 2?
Roman 2.
Hmm.
To be within available bid capacity adjusted account for his bid price, which is evaluated the lowest in the package contract shall be awarded to any bidder whose available bid capacity is less than evaluated bid price. Even if the bid is lowest evaluated bid, the contract in case of awarded next lowest bidder at his evaluated bid price.
There's a scope.
Scope, see
It's not necessarily, generally a lowest bidder, L1,
Mal-
and then there's a provision that can be given to the next lowest bidder, subject to what is to be done in this, is prescribed here.
I'll just this point I'll come, you see page close 29.5, Even if say that if the bid is in case of lowest bidder, if it is unbalanced, there's absolutely unbalanced. In that case also, those unbalanced amount has to be in order to set up that unbalanced bid, the bidder is required to furnish the additional amount to make over those the unbalanced amount, even if it's unreasonable, it's unbalanced,
Then how do we read this 29.5 and this 31.1 Roman 2?
It is about a bid capacity, Now, my bid capacity, it is not a case of bid capacity, but this Roman 2 is about the bid capacity, within available bid capacity.
It's okay. Yes. What is the reason of his rejection?
My lord,
Admittedly, he's L1.
my lord,
It appears to be due to submission of unsatisfactory justification of quoted rates. What
Yes.
does it mean?
yes, my lord. Why?
Is it a ground for rejection?
Yes, my lord. My lord, his
Where it
own
is?
admission
Hmm.
is that he has quoted minus 15%. My lord, if minus 15% below,
What is the provision that if a bidder, quotes that, then
my lord
if
will
it
kindly
is-
come to page 146.
Ah.
This is the CPWD manual. Abstract, yes. 146, my lord. 20.4.3.2. Acceptance of tender at justified rate with allowable variation. A proposed provisions under so and so, variation up to 5% over the justified rate may be ignored. Variation up to 10% may be allowed for peculiar situations and in special circumstances. Reasons for doing so shall be placed on record. Tenders above this limit should not be accepted, madam.
So his is 15%.
15%.
Below the.
Yes.
I think there's a judgment of this court.
Yes, it's Malab.
Where it
That is Malab, absolutely regarding this Malab.
Where it is? Do you have that
Malab,
judgment of this court?
Malab,
Not this court.
Malab, there was Malab. Malab, I'll just.
Where it is?
My lord, this is my lord, what,
I think we appeared along.
my lord,
together.
that is right, my lord.
Huh? Where is the judgment?
My lord, is there, my lord, I could not bring today. My lord,
So-
page 145, my lord, you see it. We have on page 145, my lord. This is 145, my lord. This interpretation, my lord,
Hmm.
145, my lord. 145, my lord, as per the 145, my lord, the office memorandum issued by the Commissioner PW, my lord. As per this, my lord, L1 has to be, my lord, accepted, my lord.
Where it is?
My lord, it is observed that various PW zone, circle, division, public work department are generally accepting tender other than L1, which is in contravention of Central Vigilance Commission CVC guidelines contained in the memo number so that my lord, to 20.5 CPW work manual 2014. Receipt, opening, scrutiny, and acceptance of tender must be in total agreement with the provision of section 20 of CPW work manual 2014. In conjunction with all extent the notification and guidelines issued by the government of India from time to time, any lapses irregularity committed by way of non-compliance with CBC guidelines and CPW work manual have given rise to the huge number of the contractual litigation, which not only lead to loss of the precious time and energy of the government in defending them in litigation, but also huge drain in the meager public resources. Mounting court cases over last few years has put the state government in embarrassing situation. The state government has viewed this state of affairs.
No,
very
basically what is
My lord,
L1 has to be given.
Yes, yes.
Provided it is complied with the CPWD manual.
Yes.
my lord, CPW, my lord, this I post for 146, my lord. That's I just read the same, my lord. 20.4.32, my lord. Acceptance of tender at justified rate with variable valuation. The proposed provision under para 20.4.3 variation up to 5% over justified rate may be ignored, over justified rate. And variation up to 10% may be allowed for peculiar situation and special circumstances. Reason for doing so shall be placed on record. My lord, here 5% over justified rate. It's
No,
not,
that's
it
what
does
I'm
not say
saying.
that below justified rate.
I forgot it, but then I argued the matter, and
My-
there's a judgment on this point.
My lord, that is
Find out the judgment.
my lord, that part, my lord. Over and below, my lord. This is their further explanation.
No,
in
well,
the-
I agree with you. If according to your submission, it's only the above, it's not below.
Yes,
If the judgment clarifies that,
my lord,
don't you agree? That RWD matter, somewhere in Sagali, there's a series of writ petitions.
my lord,
Justice Mehdi has passed the judgment.
yes, my lord.
We appeared together,
My lord, that
justifying all those things. Whether it was in our favor or their favor, we don't know. But you find out the judgment. It clarifies this issue.
my lord, in that part, my lord, particular benchmark, it was mentioned in the SVD itself, my lord.
Sir, that's
was
why
specific.
let us
Even
look at those judgment.
Yes,
Do you have the judgment?
Sorry, I also have not brought that, my lord. But in
It
any
was
case, this,
Justice Mehdi,
yes,
Sanjay Mehdi.
we'll find out.
One of a single bench in one of the cases that was decided and it went for appeal and appeal is still pending in Guwahati.
Doesn't matter. It is stay.
Yeah. No.
Then we'll be persuaded. I mean, persuaded by that single bench.
my lord, see,
Notice has been issued.
yes,
Huh?
notice, formal notice has not yet been issued, my lord.
So we'll issue notice. Let them file that.
My lord,
I'm not convinced. No stay.
my lord, since they are say, my lord, already stay, my lord. Instead, the proceeding may go on, my lord, but abandoned work, it has been, my lord, stay, my lord.
No, otherwise it's amount to stopping the work. Why should we should allow them to proceed?
My lord, I'll just lordship, if your lordship sees the page 43, the NIT itself, my lord, that condition is there, clause it, page
Page
43.
43.
Yes. Page 42 is the NIT, Lord.
Hmm.
27.
43 where?
43,
43?
yes.
Which,
No, clause 8.
8.
A bid which is unrealistic price, abnormally low, high will be summarily rejected.
Even if it is high?
Yeah, or abnormally low.
Low.
They, both. In
That's
both
that
cases,
means his,
15% below that tender amount. Is abnormally low. That's the main ground which the department has
Now,
taken.
for that, my lord.
let us do
yes,
one thing.
yes,
Let us do one thing.
Yes.
Since there is stay, we'll fix this next week. You file the affidavit with bring the records also.
Yes.
Scan copy will do.
Yes.
You bring the records, we'll dispose them on.
My lord.
Also now, my lord, a model code of conduct, nobody will be awarded work.
So you want that there's a automatic stay?
No, no. It may be things next week. After,
Or after 3 weeks?
no, after lordship, no, next week.
So you'll not proceed with the process because of MCC?
My lord, MCC, it says that press work shall not be started, if not been started, my lord. In this case, my lord, the work has not been awarded, my lord. That's why, my lord, ultimately, that model conduct as per the directive of the election commission, it applies, my lord.
No,
That's not in start.
Mr. Tapo is arguing in your favor.
My lord, that is why.
Lordship, it may be fixed on 4th April.
Can you file the affidavit?
Yes. Actually, today itself, I called the record. The officer has not come.
Then we'll issue formal notice.
Yes.
Heard Mr. Where is that rejection, that evaluation, that the
My lord, it's page 139.
139? Heard Mr. Tita, learned counsel for the petitioner. And also heard Mr. Who is appearing for
One.
one?
Yes. And for 2 and 3.
Mr. N. Ratan for respondent number, learned additional Advocate General for respondent number 1. Mr. Peter, learned counsel for respondent number 2 and 3.
Yes.
The learned counsel to petitioner has submitted it. He has taken the steps.
Yes.
By what?
By Dusty Morton. We have filed the
He has
affidavit.
taken the
also.
steps. Service notice for service of respondent number on respondent number 4. For Dusty, which has been duly accepted by the respondent number 4. The service on respondent number 4. Therefore, is completed. By filing this writ petition, the petitioner has challenged the rejection of his tender pursuant to the e-tender. Which was the date of tender?
29 January
E-tender
2024. Base 42.
29/01/2024 for the work for construction of new fire station at Dambu, Lower Debagul district. Christopher. It is contended that the bid of the petitioner has been rejected without valid reason, in as much as the reason shown to have been reason shown is due to purportedly due to submission of unsatisfactory justification quoted rates. Mr. Issue notice returnable within 10 days. 10 days. Learned counsel for the since the learned counsel for the respondents, the learned counsel appeared and duly represented the respondents, no formal notice need be served extra copies before national learning respondents. The respondents are directed to file affidavit in opposition on or before 04/04/2024. That's all.
Madam, the earlier interim observation, madam, that will continue, madam.
Rather, we'll say that the proceed with the finalization of the tender.
Madam, the work has not yet been settled. madam.
That's why we direct them to settle it
Madam, that's madam,
till 04/04/2024. The respondent may proceed with the tender. However, no final order may be passed. No final decision may be taken.
madam.
Till 4th, we'll either, even if it's not disposed of, we'll vacate that. You bring, both of you,
Yes,
look at that single bench, it's pending before the writ appeal.
It is pending for division.
But yes, in my case only, madam, the elbow below.
It was.
You have
madam,
lost or you have won?
We lost.
We lost.
went to silver.
So we won.
The benchmark was mentioned
So
specifically. as
kindly,
given.
kindly bring
Yes,
that.
I think that.
Madam,
It's reported.
No.
it's not reported.
The MT agency is doing it.
Well, I am in a.
What is this, sir? Withdraw, we'll dismiss.
No,
No, MCC,
no.
it doesn't apply.
Well,
Announcement 16. Your order is 15.
yes.
You're in luck.
The ill luck, maybe for the reason, let me explain to.
What's the
Explain
transfer
to-
method?
to-
You go, where you have been
to-
sent to?
Each other.
It's okay, enjoy, come back.
No, it is the issue is like this.
Issue is nothing, sir.
I'm not alleging any malafide, except or the otherwise, there is a word call on the directions of. On the directions
Let
of,
us see
in the file noting.
where it is. Have you annexed it?
Yes, I have annexed the file noting. Page 36.
26. Okay, you are supposed to file an additional affidavit.
Because I, prima facie, did not find any ingredient of malafide in it. So better not to waste my time.
Okay,
Kindly come to page 36 on the top.
36.
36. There's a file noting that I have obtained. Note number 63, Milord. As directed by higher authority, the transfer posting of following officers are proposed. Now, Milord, the question is, who is this higher authority?
Who is this man? Who has written this office note? See,
This is,
section officer. It's a file noting.
Section officer.
He's not the one who has decided.
No, he is not the one who is deciding.
Therefore, he
I'm
has
trying
said,
to-
he has said as directed by higher authority.
Yes, so
Maybe
I'm
the
trying.
competent authority.
Yes, Milord, I am
That's-
trying to churn out a fact that who is this higher authority? So now it is not explicit in the file noting.
Not necessary.
That
He's a section officer. He's making a file note. At the direction of the competent authority.
that Pimpari's judgment is there. File noting is nothing but the opinion expressed by an individual officers. And that's part of the decision-making process. And there cannot be any quarrel on this.
Yeah.
Now, but then from here, I was trying to point out who is this higher authority who has directed?
Competent authority.
No, competent authority itself, he must have reflected. Who is this? Anyway, Milord, that is one apart. Therefore, Milord, the first, I am not quarreling on my tenure. I have completed my normal tenure of posting. But, Milord, only the thrust of argument is that 02/06/1998 guidelines, my lord is fully aware my brother Tapin will say that the first clause is against me because I am from same now Khamli district, the Pajero district, and then posting is there. But then, my lord, 1F clearly says that there cannot be a mid-term financial year transfer. My lord, that particular guideline, my lord, is aware, and there are so many orders which my lord have also granted. But then here, my lord, only thing that my lord will kindly
You
keep
just
it.
tell us what is to be done today. It's not prejudge or predetermination like that, but there's nothing.
I want my lord to dispose either this way or that way, this judgment, this order, without keeping it. Because whatever argument I wanted to
So your
advance-
only ground is that there's a violation of this guideline.
My lord, equally, my lord, let me clarify. By projecting that guidelines, I am not creating any legal rights of the petitioner because guidelines is not an enforceable right. But the authority, while deviating from the guidelines framed by them,
But it's a professional.
yes, must
Professional.
yes, but my lord, they have to give the reasons. Here, there is no reason, my lord. No reasons, nothing. My lord will kindly see.
In the file.
My lord will kindly see page 37. It is clear from the note sheet, my lord. Now here, my lord, kindly see.
37.
37, sir.
You have shown it already.
No, 36 shown, my lord. 37, my lord. Note number 67. It is by the commissioner, principal secretary. No, joint secretary, my lord. Transferring at this stage may invite stay from courts as it is the month end of the financial year. For order, please. My lord, kindly see, there is no reason assigned at all. But then sometimes, my lord, transfer and posting, my lord, that Govardhan Lal judgment, my lord, 2004. I cannot insist that I should remain in a particular place of posting of my own choice, my lord. And then that Silpi Bose judgment, my lord is aware, on several occasions together we have relied on. Unless or until if mala fide is not alleged, or which.
See, suppose you are transferred within the financial, before the end of financial year, what prejudice will cause to you? What prejudice will cause to you?
Whatever was
According to you.
Whatever was to cause already caused, my lord.
Then
In
better
the
it's there.
in the lightning speed, they have at 4:25 p.m. the order issues or order approval is accorded by this competent authority. And my lord, kindly see at the stroke of night, they have taken charge, they have forced the deputy commissioner to release me from the election duty. And in the night, they have taken the charge. My lord, it is a profession norms, my lord, that after 5 o'clock, there is no office hour normally. What is this? My lord, this arbitrariness, my lord, does not need mala fide also. Arbitrary action can always be the action that deviates from the profession norms, my lord. Only my lord will pass some order, my lord, today. Or my lord, till 28, let there be an status quo order in my favor.
Why 28?
I'll conclude everything. I'll close the accounts and all, because there is a WT message that officers who are into the mid thing, they should not be shifted out because implementation of the projects and all. Because I have not given the charge, they've taken expenditures. I'm not aware of that Nyamurina judgment also. There's so many orders my lord have passed, which I need not to rely. The principle is very loud and clear.
This caveat.
Which aviator who has served already, he has not come today.
Mr. Bui, he appeared for the private restaurant.
He was
Okay,
happy
wait.
that on the ground that he has taken expenditures.
There is no ground.
Lordship.
he has fairly submitted that there's no ground other than this violation of the guidelines.
Lordship.
And of course, he said fairly that it's not enforceable. There's no nothing.
Lordship.
What do you want to say?
Lordship,
Why last second of the financial year?
Lordship,
Month? Why?
last time I placed one instruction issued
Yes.
by the Election Commission of India.
Yes.
I think it must be here, Lordship. Lordship will find this instruction was issued on 21st December 2023, Lordship.
Yes.
The serial number 2, Lordship. The commission has been following a consistent policy that the officer directly connected with conduct of election in an election going state /UT are not posted in their home district or places where they have served for a considerably long period, Lordship. Then hence the commission has decided no officer connected directly with election shall be allowed to continue in the present district, so and so and so, Lordship. This is the issue, instruction issued by the Election Commission.
So
of
he's
India.
from,
He is from the very constituency, not only from the district.
he's
but-
the only officer which you have transferred
Lordship,
all
that,
over entire state.
that aspect, Lordship,
I'm just wanted to know.
Lordship, that aspect, Lordship, because at this stage, and
So
then-
according to you, transfer of the petitioner is because of this condition,
Lordship,
because of this requirement.
Lordship, then I'm coming, kindly come, then,
Is it applied to all other employees?
Lordship, I believe that it has been, Lordship, applied, but in some cases, if it has
Because
not been applied,
it's not a common transfer and all.
Lordship.
It's the petitioner and the respondent only. So
No,
it's
see,
been,
here
it
no
has
say-
been a common transfer order applying this letter
And not
by the
reflected.
commission.
Lordship,
Nothing is-
Lordship, that I can understand, Lordship.
Well, only
Whether
if-
this
what my
instruction-
brother Tapin, whatever
Yes,
is submission,
yes,
my lord,
yes.
is not reflected in the
Yes,
final
yes.
voting. He cannot take this plea.
This instruction, Lordship, whether it has been, Lordship, uniformly applied, Lordship, to every Lordship in every district.
Of
or
course.
not. That aspect, Lordship, is another thing, Lordship, because that is not before us, Lordship. We are, Lordship, the issue.
No, why I'm saying, because
Hmm.
it appears to be a single transfer.
Hello, there. Then, Lordship, kindly come to this very.
Of course, they are not, pleading, there's no pleading with regard to mail affidavit.
Lordship.
That's why he was given a chance to file additional affidavit, and he has fairly said that there's nothing like,
He has no malafide.
No mail affidavit.
Then, Lordship, here, Lordship, transfer policy of the state government, Lordship. Here, Lordship, group A and B, Lordship. They must not be, Lordship, posted to the home district. Because here, Lordship, the sole ground, Lordship, there's a violations of the, Lordship, this very policy, Lordship. This petitioner himself is
Is-
here,
is-
Lordship, in violations of the very
Is
policy.
your record supports that?
Lordship, this is, Lordship, apparently, Lordship, in pleadings, Lordship, 3 years and 9 months already spent.
No, it's okay. That is different issue. When you are taking that because of this condition, election commission's letter,
Lordship.
if you are submitting that he has been transferred in view of this, is this
Lordship,
supported by
Lordship,
your-
here in this case, Lordship, not even a notice has been issued or I am directed to bring the instruction also.
Okay.
This court did not satisfy with the, Lordship, the case, Lordship. It was, Lordship, agent for the past time giving him to think over whether to withdraw or not, Lordship. This second chance, Lordship, to bring on recourse if malafide can be taken as a ground, Lordship. I am not even directed to bring the instruction also, Lordship.
Have you filed the affidavit?
Lordship.
Have you filed affidavit?
No, Lordship. Since, Lordship, there's no direction, Lordship. And that apart, Lordship, in terms of that, Lordship, transfer order, the private respondent has already taken over the child, Lordship. And he has been given the, Lordship, election duty, Lordship. At this stage, Lordship, when, Lordship, the election duty has been already given to the private respondent, Lordship, the vesting, divesting, and again vesting, Lordship, if interim is granted, Lordship, it will interfere the, Lordship, very election process, Lordship, which is not, Lordship, not advisable at this junction, Lordship. So that is, here only the prayer is, Lordship, up to this 31st of March, Lordship. Now today is 26. Question is of 4 days only, Lordship. Now, 4 days lawsuit, if any, for example, if any stay is granted, will that serve the lawsuit public interest lawsuit? At this, when situation is not normal lawsuit. Had it been the normal situation, there's no election lawsuit. Then lawsuit, I would have lawsuit on past day lawsuit. Because he wanted, prayer itself is lawsuit till 31st of this March lawsuit. I would not have objected lawsuit. And court also is lawsuit, understood this very lawsuit situation lawsuit.
I am not understanding.
No.
I'm hearing you now. I'm yet to understand.
No. Court, I'm referring the earlier hearing lawsuit. Hearing lawsuit. And on record, I placed the lawsuit, the private respondent has already taken over the charge. Earlier, he was given the election duty, and in his place lawsuit, modification order has been issued, and private respondent has been given the election duty lawsuit, and he is functioning lawsuit, their lawsuit.
He has given the charge.
No, it's only on record. I have
He has given the charge.
No, we have not given the charge.
How can you? This it amounts to you will invite disciplinary proceedings.
No, well, it was like this, 4:25 PM, the order was approved. And thereafter, in the stroke of midnight of the same day, the
See,
reliever.
midnight submission is not.
No, that, see, sir, you are trying to otherwise. Practically, you are trying to submit taking some malafide ground. That's why this court directed you to file an additional affidavit since you have not taken the plea of malafide. Today you have not filed it, and there is no other ground except to say that there is a violation of guideline. There's nothing.
No, well, respectively,
can be
whatever, because like their lordships have to pen down. So I am nothing, but as an officer of the court, my lord, my duty is to present the facts before the court.
No, it's okay.
Before their lordships renders a judgment. My lord has seen page number 36 and 37. My brother Tapin has taken the shelter of these guidelines, but the transfer and posting order was not initiated on the basis of this. Therefore, your contention that this, on the basis of these election commission guidelines, the transfer has been initiated is not sustainable, respectfully on the first ground. Second thing, in Katina of orders and the judgment by this honorable court itself, whenever there was a mid-term financial transfer, the court have interfered. And accordingly, on perusal of the file notes, my lord, when I find that there is no UO note where I can invoke the ratio laid down in Mahmoud Masood judgment, then I did not do that because I did not find any malafidness except for the word higher authority.
No, that's what I'm saying. That's why, therefore there's no ground to interfere in this transfer method unless you are not pleading any malafide and your submissions. Though you are not taking particularly, specifically, you are not taking the plea of malafide, but the submission, the way you are making your submission,
Malafide,
like you are alleging malafide.
No, malafide.
That's the reason I think this court has given you the chance to file.
Respectfully, my lord, but malafide I cannot take on the basis of the record that is available with me. But, my lord, arbitrariness can always be without malafidiness also. And from the file note itself, my lord, it is discernible that there was an arbitrary action because it is a single case of transfer. My lord will pass any order because
There is no bar that.
Well, my lord will also kindly. My lord will also
cannot be transferred.
No, my lord. That's why I said Govardhan Lal case, my lord. Just give me 1 minute.
It's okay. It's okay.
That particular judgment we said is a transfer and posting.
Well, let us not make ourselves complicated by relying on those things if you are not ready.
No, I'm not relying, just point out so that we refresh ourselves.
It's okay.
Yes, I have plenty.
What is to be done?
Avani Kanti Ray versus State of Orissa, 1995.
As a matter of law,
it is settled law.
It is not sufficient lawsuit when only the rights has been violated lawsuit. Lawsuit petitioner has to show lawsuit how he has sustained the legal injury lawsuit. Here,
Will not stay the transfer order. Will issue notice. You produce next week. Will dispose. There is no ground for stay, sir. Sorry. Heard Mr. Titi Tara learned
My
counsel.
lord, instead of that, my lord, kindly dispose of this matter.
Or else you withdraw it.
I'm not going to withdraw. my lord.
Okay.
My lord will dispose of this matter.
So then you will not take you will not refer to I'll not record your submission when you which you have referred to this file noting. Would like to see the file noting.
File noting I have annexed obtained through RTR.
That's why we would like
Okay,
to see
Then my
file
lord,
note.
issue notice. No.
Next Monday we'll decide. We'll
No,
dispose of.
Next Monday may not be possible because from tomorrow I am also leaving for nominations. And tomorrow my lord will have a thin attendance in the court also, except for the
It's
youngest.
okay. We're not concerned. Heard Mr. Titi Taralan counsel for the petition. What is that impure order? Transfer order? Page 27.
Yes, page 27.
By filing this application, the petitioner has challenged the order dated 15/03/2024, by which the petitioner has been transferred from Yajali Division, PW Division as executive engineer to the office of the chief engineer within bracket BIG dot and training TRG dot page 28. Sorry, page 27. Against the respondent number 4. Mr. Titi Tara, while referring to the page 36 and 37 of the writ petition, which relates to the file noting of the department, submits that the file noting itself shows that the transfer has been issued under the direction of some higher authority, which is clearly arbitrary in nature. Issue notice, returnable within 2 weeks. 2 weeks. Returnable within a week. Mr. T. Tapil, a senior government advocate, appears for state respondent. None appears for the respondent number 4, even after filing caveat. The learned counsel for the state learned senior government advocate is directed to produce the record.
Lordship, after 2 weeks, the matter itself will become in process, Lordship.
Then?
No. It case for dismissal, Lordship.
My lord can my lord. Why I am saying is, my lord will lay down the law.
Then returnable by 28/03/2024. Friday. On Thursday.
On which date he will bring the file note? That's all.
You place the file.
Yes.
Record. We'll dismiss on that day.
Lordship.
But I would be happy that my lord would be laying down the law. What happens when the authority in arbitrary exercise of powers violates their own guidelines?
We'll give you a chance to argue on that day.
Yes.
On 28. Will 28 and no adjournment.
That will suffice.
28. List on 28.
Your Lordship, this
Where's
item.
the eviction notice?
Notice the page number 37.
37.
37.
Yes.
Whereas the Socus notice was served on Mukesh Deori by memo number this is for violation of section 25 D, E and F of Assam Forest Regulations 1891, Regulation 7 as adopted by the state of Arunachal Pradesh and under Rule 321 of Arunachal Forest ejectment of unauthorized persons from reserve forest rule 2013.
whereas the representations claiming the authority of your occupations by your representations dated nil is not accepted
It's
by.
a reserve forest.
This is not a reserve forest.
Are you staying there?
Yes.
Are you staying or you are just occupying?
No, I'm staying there. My allotment, that record is there in the CITA registered prepared. by
Forget
the
about
month.
Sita register. It is a reserve forest. You are staying there.
No.
Are you staying there?
Yes, that's a village.
Huh?
That's a village. That's a surveyed village. That's an authorized village. In 1970, survey was made. Accordingly, 1979, CITA registered was made. Dark number is there.
Then
Area number, everything is there in that particular area.
are you challenging the notification of 1982?
82, because I applied for this particular notifications, I have not received. I will challenge this also.
Until that goes, nothing can be done.
Your Honor,
You
because
back it.
this is the record, because administration has issued a circular in this regard, saying that, may I come to page number?
What's wrong here? If it is a, are you saying this 82, the notification is there?
82 notification. Now only I learned that our land was declared as a reserve forest. But till then, till this notification was, nobody had came to us saying that this area belonged to reserve forest, until reserve forest, not reserve forest.
When you have made a statement that you are staying over the land,
Yeah.
are you or just occupying?
No, I'm staying there. That's a settled village, you know. Can I come to page number?
See,
19.
village could be consist of so many areas.
No, yeah, 19, yeah. No, annexure 3. That's a meeting conducted by the ESC.
Huh?
Page 19.
19.
19.
Hmm.
That's minutes of meeting which was conducted by the Extra Assistant Commissioner Dayun.
Hmm.
Here I had mentioned it's para number 3. Sri Mukesh Deori, JPM of Dayun, informed that the location at Sumpoi village was a settled village during 1970, and the government provided land to the families settled at that location, but he could not understand now a settlement village of 1970 could be declared as ARF without taking consent of the settlement. He demanded for adequate compensation for the families like to be affected. He further asked to have discussions with the stakeholders at Oil India Limited Authority of an amicable and acceptable solution.
Oh.
Accordingly, Your Honor's circular was issued by the ESC, which is in page number 23, Your Honor, or 24.
This is your statement only.
This is my statement.
Yes.
But here, since I had the stakeholder and every record is there with the authority.
Hmm.
So ESC had issued a circular, which is 21st April 2020. In view of the meeting conducted with the stakeholders of assets in Sumpoi 2 oil dealing location, the survey will be conducted on 5/5/2022 at 10,000 at the location to assess the assets of stakeholders for further submission to the DC Changlan.
What happened thereafter? What happened thereafter?
Thereafter, they had conducted the survey, joint survey, and they had submitted the report.
Then
And here, Your Honor, again, I had submitted a representation accordingly to the deputy commissioners.
where is the report? Survey report.
Report is not with me, though I had sought for, they had not provided to me.
You have asked for land compensation.
Yes.
That will be taken care. But then this until you assert your right,
If my right is there, annexure 10, Your
and
Honor.
this impugn eviction is by the forest department.
Forest Department.
They are nobody to give you a compensation. Who will pay the compensation?
Authority.
What
District administration.
authority?
District administration.
Forest department is not.
No.
They are acting under the law only.
No,
It's
Your
a
Honor,
forest land, wrongly or rightly, it has been notified. You
But-
pursue the compensation.
compensation, but at least.
If you can establish, we'll give you that liberty. But no,
At least
admittedly now by
1982.
1982, this
Till
is
the-
notification until it is challenged or
No,
first some
I
order.
will pray for the state till returnable that until next day. I will challenge because I had applied for the through RTI.
No, your by your own showing, this is a forest land, wrongly or rightly. This
No,
is the
Your Honor.
notification.
Because I had
And the eviction, this impugn order and this is under the law.
I had even annexed the CITA register prepared by the Mandal administration, which
concerned.
is in 1979, which shows that land belonged to me. It's in annexure 10.
It's
30
in 1982 notifications. Since if you are settling there, before that, what you are doing?
Because we, every record shows that that land belonged to us. Suddenly they issued us a notice saying that this belonged to, yes, Achal Reserve Forest. So before that, no notice, nothing was issued to us. Even they had not taken consent or any map, any notice was issued prior to that. Had they we had learned about that this land
Is
belongs,
it a private land or is it a
it's a
allotted
private-
land?
It's a private land because as per the SITA is the dark number is
How
there.
could you be allotted? How could you own a private land?
No, here you know dark SITA.
Forget about it, it's okay.
SITA register is prepared by the mandal. So allotment was there. Who is holding how much land in that particular area?
Yes.
With that dark number.
My lord, in fact, he should first challenge the notification of 82, my lord, whether that was properly issued, notified or not. That is a matter to be examined, my lord.
That is to be examined. because
But without doing that, he does not acquire any right, my lord, challenging the eviction on. That is his own admission.
But then if they are staying, will it be proper to eject them?
It is not that after
Where have you made your statement that you are staying over the land, on the land? Don't say that village. Village, we understand.
that's stated here in para 5 even. That just that I will come straight. Preliminary discussion to work out a solution for implementing this briefed compresses Sumpoy. Here I said Dayun. In the meeting, the extra assistant Dayun briefed on the complexity of the granting compensation for the location at village Sumpoy. As the area locations under ARF, hence compensation cannot be granted to individual. However, occupants have been enjoying their occupation since 20-30 years back. There shall be an unanimous concessions between the parties so that the work of oil drilling could be started. In the meeting, the GS informed that the location at Sumpoy village is a settled village during 1970, and the government provided the land to the families settled at that location, but he could not, these things I had stated, and again, para number 13. I had stated, Dumble back to state, being the owner of the petition in possession and occupation of the land as shown in the sister register, which was written in the year 1979 against the surveyed village, accordingly without any interference and claim from anyone, not even from the forest department. The petitioner is exclusively adjoining the land as mentioned in the sitter register till date.
But you are not saying that you have the home and all there.
That's a settled village, you know.
You are just saying settled village. If it is a village, if the people are settled, Mr. Additional AG,
Yes, madam.
how you can give it to for oil drilling? That to a reserve forest area.
There is
Has
also,
the- has-
there is
has-
also
Huh?
one aspect, my lord, whether the reserve forest can be without
Yes, whether the process has been followed again.
de-reserving it can be used for a
If you are
non-forest.
if you are evicting them, that it's falls under reserve forest.
Hmm.
How you can
Again,
just
it
can
cannot
give it
be-
for drilling
That is,
purpose,
that is-
unless you follow the procedure.
Yes, my lord. If first it has to be de-reserved, if it is not, if it is going to be used for a non-forest.
Because the
activity.
main region of issuing Soga, they will hand off the land to the oil department.
My lord, then notice may be issued for today, my lord. Let the response come from the forest department also. This aspect also can be clear.
It's for, it's a cultivation area only. You are not
No, it's a
staying over the
cultivation.
land.
There are betel nuts are there, tea plantations are there, our home is there.
Well, issue notice, then we'll just, you maintain the status quo.
Status
Will not stay as such.
Okay, status quo.
All right.
Yes, sir.
Heard Mr. D.K. Deori,
DK.
learned counsel for the petitioner. And also heard Mr. N. Ratan, learned additional advocate general for the state, appearing on behalf of all the respondents. Huh?
Yes, my lord. All the respondents.
Next para. Challenge in this writ petition is the eviction order dated 13/03/2024. By which the petitioner is sought to be evicted for violation of section 25 D within bracket, small d, bracket E, bracket close, and F, small f, bracket close, of Assam Forest Regulation 1891. Mr. On the ground that as the cultivation area occupied by the petitioner falls under the Dayan Ansal Reserve Forest,
Anchal.
which was notified in the year
1982.
1982. List. Next para. It is the contention of the learned counsel for the petitioner that the area from which the petitioner is sought to be evicted is a settled village which the petitioner has occupied since
1970.
1979.
70 or
1970. Listen. According to the learned counsel with the petitioner, the petitioner is sought to be evicted, sought to be removed from the area so as to pave way for permitting the Oil India Corporation,
Oil India Limited.
All India Limited for oil drilling purposes. Issue notice returnable by 3 weeks
Till that
since
status
Mr.
quo.
Since
Till that status.
returnable by 3 weeks. The since the state since the state is being represented by the additional advocate general, no formal notice need. However, extra copies will be furnished to the students. Next one. Considering that next paragraph, considering that the petitioner has been settled in the area since 1970, and there appears to have been a discussion with the concerned authorities for settle the issue. For settlement of the issue of mining activities, oil drilling by Messrs. All India Corporation.
All India Limited.
And to that effect, certain discussions have taken place, including for compensation and other related issues come up in the interim parties to maintain status quo till returnable date. At least after 3 weeks.
That's all the same, only the number is different.
Same area.
Same area, same locations, only the impugn notice number is different.
In that case, you just mention the name of the petitioner. First is, I think 5 is Mukesh Deore in all the orders. Same order but separate order. It's a order, eviction order is same,
Or eviction content is same, only the number is different.
not number, the date of.
Date same, date is same, only issue number is, memo number is different.
Requisite extra copies not.
Okay.
I've said. Then you mention impugn, challenge made it is the impugn orders and number, huh? The page 37, huh? You mentioned the memo number.
Problem.
May I please, Your Lordship? Lordship, this is the,
What's to be done?
my Lord, as I am informed, tender, some last date of submission is already over on 23rd
Ah,
and is not finalized,
Hmm.
even not evaluated, my Lord. Only my prayer is I may be allowed to, my Lord, participate by
no,
extent,
if the last date is over, how can we extend the last date?
my Lord,
That will be reverse consequences.
my Lord, since my
We'll
writ
be
petition,
inviting another dispute by permitting you there.
my Lord, since the tender is not yet finalized, basically our prayer is for extension of the time, my Lord.
No, that's why I'm
That has already expired on 23rd. But however, my Lord, it is not yet finalized, my Lord. Only, my Lord, there's some opportunity, at least fair opportunity, like, my Lord, giving me permissions to, my Lord, submit the tender, my Lord.
Who appears for?
My Lord, G. Tarak, my Lord, I contacted him over telephone that he is not, my Lord, present today. So he is out of his station, my Lord. Otherwise, my Lord, even if I'm
We'll
allowed,
pick it up when he's coming back. When is he appearing?
my Lord, after election, he will be. Difficulty is, my Lord. We convince him to receive the even the advance copy, man.
He has not.
He is not available in the station, man.
Ah,
He is the only standing counsel for the RD department. Even government, the council cannot represent me.
commissioner also he appears.
My Lord.
That's the difficulty.
My Lord, only other is, my Lord, only my, if I am allowed to, my Lord, to participate, submit my tender, nobody is going to be prejudiced, my Lord. Just to that extent, my Lord. Right or wrong, my Lord, the merit is other part. But
No, this it's the last date is over on 23rd. So we cannot. How can we extend?
No.
Will not be permissible.
extent, my Lord, in respect of petitioner, my Lord, and
No, that's why we just wanted to. I mean,
and this was filed on, my Lord, before the date of, it was moved on, my Lord, filed on 22nd, my Lord. Admitted.
no, if the department accept your submission, we can pass that order. But then otherwise, we cannot extend like that.
My Lord, after scrutiny, the counsel for the department will be available. So at that, therefore, my Lord, the matter may be keep for, my Lord, the only, my Lord,
No, then in that case, we'll fix this matter after some time. You ask him to appear,
on 30,
and you request him as well. That
Let it be
Well,
on first, my Lord.
first,
April,
First or 2nd April.
my Lord.
in any case, nothing will be proceeded now. Will it be? Will it
I
be
believe
as per the MCC?
My Lord,
MCC.
my Lord, as per the clause 17,
Hmm.
it cannot be finalized, my Lord. Even if it is evaluable. Not to finalize, even if evaluation is done.
Tender other than the
Clause
global
17.
tender that are already plotted may be evaluated but not finalized without prior approval by commission. They can finalize after approval of the commission,
My lord.
right? Nominee, they will not finalize.
Finalize-
We'll go for taking.
Finalized part is,
because
my lord, is clear, my lord.
We'll
But-
take it up on
My lord.
Monday.
Monday.
You ensure that he
Yes,
appears,
I'll
right?
personally request him.
So we'll not issue notice.
My lord.
Third, Mr. M. Kato, learned counsel for the petition. List this matter. On the prayer of Mr. On the prayer of learned counsel for the petition, list this matter on 01/04/2020.
My lord. The proposal.
You convince him
My lord.
that your prayer should be accepted at
My
the
lord.
department. Then only you can, otherwise
My lord.
it's very difficult.
Otherwise also, my lord, nobody is going to prejudice, my lord, only allowing me to, my lord, participate in the.
No, they may come tomorrow. That had he not, suppose if you get the tender,
Correct.
someone may come that if
After
had he not
expiry.
been allowed, had he not been allowed, he would not have been awarded the work.
My lord.
Rather than resolving the issue, we may create a problem.
Yes.
Anyway. Which one? So we'll see at 2 o'clock.
Deeply visible.
Item number 19.
It is noticed that last 3 consecutive times, none has represented the parties may not be interested to proceed with the matter. Mr. Howard. No, you just read after the second line. Second sentence, you deleted. It appears that the parties are not interested to pursue the matter. Mr. Howard, as a last opportunity, list this matter after 8 weeks. On which date, if none appears for the parties, appropriate order shall be passed.
Item number 20.
What happened?
Your Lordship,
What had happened?
there was no settlement even on
No
the last,
settlement.
yeah, even on the last occasion, when it was listed before Justice Yukine, there was a suggestion made by him that better both the parties go to the Kaba, Your Lordship. However, after that, this matter has come, the learned
is-
councils are
What is to be done? List after 4 weeks.
3 weeks, Your Lordship,
List this matter after 4 weeks, 3 weeks.
3 weeks, Your Lordship. Deeply. Interim, Your Lordship, is
Interim order was the list will continue.
deeply.
Item number 28.
Your Lordship, we are praying for interim in this matter, whereby my LPC was cancelled by the Deputy Commissioner without giving me an opportunity to be heard, Your Lordship. So now the person who had actually given the application along with the forged affidavit to the Deputy Commissioner stating that I have withdrawn from my LPC.
Any
Now-
instruction?
Yes, my lord. My lord, instruction is that the petitioner himself has shown an affidavit. If my lord comes That's the serial number that I have obtained LPC bearing so and so, sir. Then at serial number 3, that I herein surrender my above mentioned LPC in favor of Sri Iken Tao, so and so. On the basis of this only.
Yes.
Lordship, if I may, Your Lordship, that's why there is a complaint letter that has been put before the DLRSO, stating that they had forged my signature, and we have also filed an FIR before the police station, Your Lordship. That FIR has also been enclosed. That was not my signature. This is the prayer, Your Lordship. That the affidavit has been forged.
Where it is, where you have made this statement,
Your Lordship, if Your Lordship will see in page number 30 is my FIR.
where you have made this statement. You said you have not been given an opportunity.
Yes, Your Lordship.
When you have given already and by filing affidavit, surrendering your LPC with the question of opportunity.
Lordship, that affidavit itself was not submitted by me, Your Lordship.
Hmm.
Even if Your Lordship will see the order, had I submitted the affidavit on my own, Your Lordship, I would have submitted along with the LPC. But in this case, an application was submitted along with the affidavit, which was not mine, Your Lordship.
Page 24.
Yes, if Your Lordship will come to page number 7, that is the FIR. Lordship, page
Page
number.
24.
Yes, Your Lordship.
Where is the FIR?
FIR, I have given in page number 30, Your Lordship.
Huh?
Page number 30, annexure 7.
This complaint is cancellation order is which date?
Cancellation order is 11 July 23, Your Lordship. Oh, Your Lordship, complaint, the cancellation was on 13th. So on 10th, the affidavit along with an application was submitted before the Deputy Commissioner, Your Lordship. On 11th, I have submitted an application before the DLRSO stating that some unknown person has submitted the application, Your Lordship.
13 July. And
Yes,
then
Your
where's the FIR?
Then FIR, Your Lordship, will come to page number 30, Your Lordship.
30.
Yes, Your Lordship, page number 30. That is after continuously approaching before the learned respondents.
So what
Since they have not taken any action, then
what happened to
thereafter.
this FIR and all?
Lordship,
FIR.
FIR is in page number 30, Your Lordship, annexure 7.
No, that's what I'm saying. What had happened?
The investigation is on the process, Your Lordship.
No, you have given in the impugned order, you have clearly given that the application allowing the affidavit has been received from so and so, huh?
Yes, yes. Now,
The lawyers for cancellation of land possession issued by this office and so on the strength of affidavit submitted by Srimati so and so is cancelled, and thereafter she has filed a complaint one after another, including the FIR.
yes, my lord. Now, therefore, my lord, whether that affidavit is genuine or not, that has to be decided first. That is by way of that they will investigate whatever outcome. Now, authorities, they have acted bona fidely, whatever was in their knowledge. Now, this, therefore, the cancellation, that will be subject to what is the finding of the investigation, whether this affidavit was forged or not.
But if Your Lordship will see.
Now, how the writ court can decide when there is a contention, whether this is forged or not.
We are not before this honorable court to check whether.
But you are supposed to take a call. Where's the officer in charge? Is the respondent?
Yes, Your Lordship.
Was the officer in charge or IO is the respondent here?
No, Your Lordship.
You make them a party.
If Your Lordship will see, we are only.
Has it been registered?
Yes, Your Lordship, it has been registered.
Huh?
It has been received on. It has been received on 11/7. Your Lordship, it was.
You don't know whether this has been registered or not.
It has been received, Your Lordship, on 28
Received we have seen,
2024.
but whether this has been registered or not.
Since Your Lordship, this is a case of forgery, so the matter is not directly registered. It's a non-FIR. So after the investigation is taken up, then the matter will be registered. As of now, the investigation.
Okay, then whether the investigation has been taken up or.
Yes, Your Lordship, it has been taken up. Their statement has also been recorded, Your Lordship.
Hmm.
So in this case, we are not praying that this has to be taken into consideration, that the affidavit has been forged. We are before this honorable court with a simple prayer that the application, my LPC was cancelled without being heard, Your Lordship. on 11th. So it's like any person come up.
Once you have filed an affidavit saying that you are surrendering, it was the question of hearing you.
That is there.
So
but-
now, according to you, this is forged one.
Yes,
So
Your
until the time it is established
yes, Your Lordship.
that
But
it is the
also-
forged or not forged, then there is no question of it existence.
I agree
No
with that.
question of opportunity.
But if your lordship will also see, when this application was filed before the deputy commissioner for cancelling my LPC, the deputy commissioner ought to have given one chance to be heard whether I have submitted the affidavit or not. Because it is clear in the record that it was not I who had submitted the
You
application.
have submitted that
It was
application.
not me, your lordship. It was not I as a person who had
You have
submitted.
you have submitted the application before the DC went,
It was
after the
before
cancellation,
no, your lordship, before the DLR. So I had submitted the application.
where it is.
If your lordship will come, it's in page number, annexure 4, your lordship. Complaint against unknown person for submitting a forged affidavit trying to cancel my land possession certificate. Right on the next day after the LPC, the affidavit along with the application was filed before the deputy commissioner. Your
How
lordship.
do you know that the unknown person?
Your
How
lordship,
why you are saying unknown person? This was
Because-
submitted by the one.
My lord, in fact, the person who,
Iken Tao.
he's also not made a party here.
Ikenta has submitted
He had submitted,
application
yes.
along with your affidavit,
Yes, your lordship.
wrongly or rightly.
Yes, your lordship.
Why you are saying the unknown person?
No, that was afterwards I came to know, your lordship. When I filed this application, it was only informed to me that some person has impersonated as me and has filed the application, your lordship.
From where is the source of your knowledge? How do you know that so unknown is under process?
That was informed to the petitioner by some
Huh?
reliable source, your.
Allegation is that one Ikentau has submitted a forced.
But in that case, you hear him,
My lord, here.
hear her, and pass appropriate
That
orders.
person also has not been made a party here in the writ petition.
We'll direct the deputy commissioner to hear both of them. Right?
Yes, your lordship, that is only the prayer. If that can be heard, and even if that case, the LPC is cancelled, that would be there, your lordship. But as of now, only.
I will not say that you should cancel or recall it or cancel it, but we'll say hear them and pass appropriate orders. Right? Because the cancellation was of 13 July. And she has made a complaint before the DLRSO on 11 July, 2 days before, when she has the knowledge, when it was under process. Then again on when it was 13.
That order can be passed after they make implicit this person, the third person, Mr. Ikentau, a party here. He is also not
If
made a
not,
party.
if my prayer be heard, your lordship, this matter can be.
Then you implicate them. You implicate the IO also, the officer in
Your
charge.
lordship, this is only for hearing. If this matter is placed before the deputy commissioner, then your lordship, in the order, it can also be mentioned that the Ikentau also has to be issued notice. Then that matter can be heard. That's there itself, your lordship.
What is the problem of?
Because now, if you are impleading again, then that would be another.
Why? What is the problem?
There is not a problem, your lordship, because our prayer is only that if the deputy commissioner is given, we are given a chance to be heard. Only that much. So even because we also file the FIR.
You make an undertaking that you will not come back again.
But that also has to be seen how the order is passed against me.
Ms. Arthak, learned counsel for the petitioner. Also heard Mr. and not learned counsel for the learned additional advocate general. It is noticed that since the impugn order of cancellation of LPC has been made in favor of one Sri Ikentau, who has not been arraigned as respondent in this proceedings. I deem it appropriate to direct the learned counsel for the petitioners to implicate the implicates Sri Ikentau, in whose favor the impugn order has been passed. Mr. It is also noticed that the FIR has been filed, which is shown to have been received from the IO of the case may also be implemented as party respondent. The learned counsel for the petitioner is granted 2 weeks time to 1 week time to take
Lordship,
appropriate steps.
2 weeks time.
2 weeks
Yes, sir. Lord.
for filing affidavit. I mean, for implement.
Yes, sir. Lord.
It's just a formalities. We'll hear them and we'll pass the orders.
Yes, sir.
2 weeks time. So as to enable her to take appropriate steps. This after 2 weeks.
Much obliged.
Item number 25.
May I please, Your Lordship?
Yes.
Your Lordship, the accused has been arrested on 10/8/2023, and it has been 230 days as of today. Accused was arrested in the NDPS case under section 21B, and he was arrested on 10th August 2023, and as of today, it is 230 days. Your Lordship, Your Lordship may come to the page number 11.
215 days.
230 days, Your Lordship.
30.
Yes. 230. I'm so sorry, Your Lordship.
230.
30. Yes, 230. Your Lordship, in the FIR, it is stated that upon receipt of input from the reliable source regarding transportation of drugs from Assam to Itanagar.
What is the ground of bail?
Ground for bail.
What are the ground?
Your Lordship, nothing has been recovered from the alleged accused, Your Lordship. And he has been implicated just on the basis of the accusation of the other accused, Your Honor.
Co-accused.
Yes, Your Honor.
Where it is?
And Your Lordship, it is in page number 5, page number 5C.
Page number?
Page number 5, D, Your Lordship. Page number 5 of the petition, Your Lordship. And para D.
Nothing has been recovered from him.
Yes, Your
And
Lordship.
he has been
Falsely implicated in this case merely
on the statement of the
other accused.
other co-accused.
Yes.
What
Yes, Your
is
Lordship.
what is statement he has made?
Your Lordship,
Co-accused, what is the statement?
Your Lordship, he stated that he and the co-accused and alleged accused, they conspire to traffic the drugs from Assam to Itanagar. And Your Lordship, the contraband has recovered from the co-accused, not from the accused of the instant bail petition. And Your Lordship, it was recovered from the body of the co-accused, not from the applicant, not from the accused. And Your Lordship, if the contraband belonged to the accused, then it should have been in the car at most, Your Lordship. It shouldn't have been in his body, Your Lordship. And FIR also the name of the accused is not mentioned, Your Lordship. And Your Lordship, there is no seizure witness also. There is no legally any admissible material with the prosecution to keep him for so long period in the judicial custody, Your Lordship.
Yes.
Lordship, here, Lordship, charge sheet, Lordship. Charge sheet
As filed lordship under section lordship 29(1) lordship, which is amendment 1 of NDPS 29(1), the
Ah.
clause 1, which is read as lordship, whoever abests or is a party to a criminal conspiracy to commit an offence punishable under this chapter shall, whether such offence be or be not committed in consequence of such amendment or in pursuance of such criminal conspiracy, and notwithstanding anything contained section 116 of the Inner Penal Code, to punish with a punishment provided for the offence. Their comments is that lordship, where the person possessing illicit drug does not carry it himself but entrusts it to some other person for carriage in a car, and that person carries it knowingly, then the driver of the car would be the person who transport the drug. And the
Charge
person,
sheeted under section 29.
yes, 29 of subclause 1 lordship
Let's see.
of NDPS.
Wait. You don't have the, no, you don't have the book. Don't take the book. You don't have the book. NDPS.
And your lordship, the prime.
Just wait. Yes, what do you want to say?
Lordship, here lordship, the accused lordship, he was evading the arrest lordship till lordship 6/8/2023, where he was arrested by the Assam police lordship. In the case number 341/2023 under section 399 IPC, read with section 25(1)(a) of Arms Act. Lordship, as per the statement of the lordship, this co-accused, Rajat Ali lordship, he had disclosed during the investigation that this person lordship, accused Jaimul lordship, he had repeatedly was reportedly a drug supplier who has usually sold drug in capital with the help of this accused lordship. One Abudin who was a drug supplier who usually sold drug in the capital with the help of this present accused. So he's a habitual offender lordship.
Charge sheet has been filed.
Lordship.
When
Yes,
it was
Your
filed?
Lordship, I have gone through the record, Lordship.
Hmm.
Elsha has called for Lordship, where charge sheet is
Ah.
there.
It's only section 29.
Lordship, section, yes, section 29, Lordship, and
Section
21B also, Lordship. Which, Lordship, this, it is Lordship, intermediate Lordship, Lordship, not Lordship, larger than Lordship, small quantity and less than Lordship, commercial quantity.
So,
So that's why Lordship 21B Lordship, it added Lordship in the charge sheet. Lordship, next date, Lordship fixed for consideration of charges on 30/4/2024. Next date for the consideration of charges CC is fixed for consideration of charges on
consideration of
30/4/2024.
charges.
Lordship, CC stage.
Consideration.
Yes, Lordship.
24?
On 30/4/2024.
30.
Lordship.
No, we're not concerned.
Lordship.
Whether he's
Your Lordship.
entitled to bail or not, that we'll see.
Lordship, relevant consideration of the Lordship, when the bail is granted, Lordship, it should be see that the nature of the seriousness of the offense and whether the character of the evidence and circumstances.
Any drugs is from him?
Lordship,
No, Your
he was Lordship with the driver, Lordship. Two person was there, Lordship. When
He was the driver. He was the
Lordship, he was the person who was sitting with the driver, Lordship, and he with the driver statement, it is disclosed that the
what you have from where you have recovered?
Lordship from the driver, Lordship. He fled away, Lordship.
Okay.
And Lordship, he was evading Lordship from the arrest Lordship till 6/8/2023 Lordship when the Assam police has Lordship arrested him.
He fled away.
Lordship.
And the drugs were seized from the driver.
Lordship. But he was accompanying him, Lordship. As per the statement of driver, Lordship, he was the one who, Lordship, carries Lordship with the Lordship other person. He may not be the Lordship, possession is not with him, Lordship, but he was
Ultimately, what had happened
Lordship,
after the investigation?
Lordship, after the investigation, charge sheet had been filed, Lordship, and Lordship, he was under the custody now, Lordship. He was, Lordship, arrested from the, Lordship, the Assam police, Lordship, and from here, Lordship, they, this, Arunachal police, Lordship, they bring her back and produce before the session court. So let the Lordship trial, maybe Lordship, go on, Lordship.
Your Lordship, may I please?
Yes.
Your Lordship, the fact of the case is Jayabur Rahman was not a driver. Jayabur Rahman was a driver, but the co-accused from whom the contraband was found, he was carrying the drugs. And this car also doesn't belong to Jayabur Rahman. And he was working in his shop. He was working in his shop, and the owner of the shop gave him the car key. Owner of the shop gave him the car key to accompany the Rajat Ali, the co-accused, to Itanagar. He also said that he was busy in the shop. But since Rajat Ali cannot drive, that is why he has to go with the co-accused to follow the order of his master.
But why you had to fled away?
Your Lordship, as a normal person, if police is coming, then it is Your Lordship, and
that will be a matter of trial. Where you are involved.
Your Lordship, the CC was fixed for us in March 1, your Lordship, and the learned session court was inclined to grant a bail. But your Lordship, on March 1, since learned session court was in training on that particular week, and the matter of the CC has been postponed to the April 30. And how can he stay for 60 more days in the judicial custody, your Lordship? And your Lordship,
charge sheet has been filed. Are you saying that the statutory you have a right to default bail?
No, your Lordship. I'm not saying I have a right to default vote. Your Lordship, he has already spent 230 days in the judicial custody. And if he is found to be not guilty after the trial, then what this 230 days?
Suppose if you are found to be guilty, then what will happen?
Your Honor, nothing has been recovered in the first instances. Your Honor.
Then that cannot be a ground for bail. It's NDPS.
Yes, your
Suppose
Lordship.
tomorrow you may be acquitted. That cannot be we don't see any material that you will be acquitted.
Yes, your Lordship, but the prime accused from whom the contraband has found,
it doesn't matter. That's why section 29.
No, your Lordship, the section
29.
Section 29, yes. Yes, your Lordship, he may be in the your Lordship, the 161 statement of Jainal Abdin, it corroborates that the car doesn't belong to him, and he was just sent by the Jainal Abdin, who is his master, your Lordship. And without any fault of the Jayabur Rahman, he has been implicated and is staying so much days in jail.
This is by
Jainal Abdin, your Lordship.
He's not an accused. He's
Not
not an accused.
Yes, your Lordship.
He's the owner of the car.
Yeah, owner of the car and owner of the shop, and under him this Jayabur Rahman works, your Lordship, and he has to follow the order of his owner, your Lordship. He has to follow the owner order of his honor. That is why he went to Itanagar with the Rajat Ali. You know, he had no knowledge about the contraband that Rajat Ali was possessing, Your Lordship. On the instant only when police stopped the car, then only he told the Jabur Rahman.
So why you had to play the way?
Your Lordship,
And you were arrested, you have never surrendered, you have arrested from Assam only.
yes, Your Lordship. Eventually, he was arrested. And Your Lordship, but it has already been so much days in the jail, and he is only the only brother
You
of
work
his
where?
own.
You work where? You are
He-
working where?
He used to. I used to work in the butcher shop, but
Where-
after my
where?
arrest
Where?
in nearby helipad area,
Hmm.
nearby helipad area. And Your Lordship, I want to cite one case, Your Lordship.
Hmm.
Your Lordship, in the Prabhakar Tiwari versus State of UP and others, in this case, it is of the opinion that the criminal cases pending against the accused and the seriousness of the case cannot be the basis for refusal for the bail, Your Lordship. Your Lordship, there is no evidence that he was involved in this transportation of drug, Your Lordship.
Are you saying that there are criminal cases pending against you? Several criminal cases pending
Yes,
against you?
there are two more criminal cases are pending against, but in no
Is
cases
it
he has been
related to,
convicted.
is it related to NDPS?
One is related to NDPS and one is related to Dakoti.
So in that case, bail rejected.
Your Lordship, that is for the previous criminal cases where he was granted a bail. Your Lordship, for this instant case, Your Lordship, we have to discuss about this instant case. I feel so. So in this instant case, he
In
was
this case,
nowhere.
in this case only, I'm rejecting your bail, or you list after 1 week.
Your Lordship, interim bail may be given then till the CC interim.
I'm rejecting your bail, or if you want to try somewhere else, will give you. You were saying that the learned special judge was about to grant you release you on bail.
No, Your
Just
Lordship.
because of
No, Your Lordship. I'm not saying that.
you said something like that.
The bail was supposed to be granted after the CC.
Yes.
The bail hearing was about to be conducted after the.
So you apply on that day then 30th
So
of
Your Lordship,
March.
CC was on the 1st of the March. But
Yes.
in April of 30, there is a gap of 60 days between
We
these 2
cannot
days.
turn the clock back now.
Your Honor, Your
You
Lordship.
said the learned special judge was about to, supposed to grant you a bail after the consideration of charges, which
Your Lordship.
had not taken place because of the trial court was on leave, judge was on leave.
Yes, Your Lordship.
Now the judge will be sitting on 30th.
Yes, Your Lordship.
You pray before him in that case.
Your Lordship.
Is it not sitting on 30th?
Your Lordship, trial court is sitting, but trial court is of the opinion that the hearing of the bail should be taken after the CC, Your Lordship. But the CC was supposed to happen in the March 1. Your
So
Lordship.
this now they fix on 30th of this month, right?
No, 30th of next month, Your
Okay.
Lordship. So that is the problem, Your Lordship.
On the prayer of Mr. So-and-so, learned counsel for the petition, list this matter after a week. Or
Much
bail
obliged.
hearing.
Much obliged.
Obliged, Lordship.
Why am I'm fixing this? You have understood?
No,
I'm
no.
rejecting it. But since you are saying that something different, so you
No,
think
Lord.
about it and will decide on next date. After a week, all right? After a week.
Yes, Your Lordship.
Understood? What I meant,
I'm so sorry, Your Lordship.
this court is rejecting your bail application, but since you have said something, submitted something else,
Yes.
so I'm granting you another 1 week so that you can recapitulate and come with better case laws in your support.
Yes, Your Lordship.
Because this two-line order depends on facts of the matter. It said just because various criminal cases are pending is not a ground for rejection of the bail, which you have relied.
Yes, Your Lordship.
We are not on that. Nobody said so. You yourself have shown and nobody says that there are many cases that therefore your bail will be rejected. Right?
Yes, Your Lordship.
Opportunity. Next week.
Thank you, Your Lordship.
Thank you.
Yes, thank you. Much obliged.
Obliged.
What is this?
Your Lordship, this matter has been settled outside the court, Your Lordship. And on this, we have already made an agreement dated 11th March.
What do you say? Who is appellant?
Me, Your Lordship.
Okay.
I'm on behalf of Contempt, who is currently out of station.
So we'll close it down.
Yeah, we can.
We'll close it down.
Yes, Your Lordship.
Yes, Your Lordship.
You are the
Sole respondent.
sole respondent
Yes,
that
I was the
claimant.
claimant. Yes, Your Lordship.
Claimant. It is submitted at the bar that heard Mr. So-and-so, learned counsel for the appellant, MSR Thakur for respondent, the sole respondent, oblique claimant. Come on. Next part. It is stated at the bar that the matter has been settled between the parties outside the court. Mr. In view of the above, the appeal stands, this motor accidents claims appeal stands closed.
Lordship, if that can be mentioned in the order that they are ready to pay the amount that has been mentioned in the.
If it has not been paid.
It has not yet been paid, Your Lordship.
It has not been paid, but we have made an agreement that we will pay.
Then we'll keep it pending.
Yes, Your Lordship, till it is paid, Your Lordship.
Huh?
They have, in their agreement, it was.
When you are
amount-
supposed to pay?
That I'm not aware of, Your Lordships, but
If I may submit, Your Lordship, in that agreement, they've stated that the amount has already been before the registry, Your Lordship. So if this matter has been closed, then the claimant, that is the sole respondent, can receive the amount that is before the registry.
Where is the agreement? Let us see. In that case, you come up with all those settlement and agreement, we'll
Yes, sir.
close it down on next date. All
In
right?
that, a short date, if that can be given, Your Lordship, short date, if. it is-
April 4 will be.
Then in that case, you just delete this last one. It is stated at the bar, the matter has been settled between the parties. Please stop. The next para. However, no documents, no document has been placed to that effect. Please stop. Therefore, the learned counsel for the parties are directed to place on record the settlement, if any, between the parties. On next date fix, list this matter on 04/04/2024.
Much
Bring
obliged.
it that and we'll
Yes, sir.
record that and
Yes, Your Lordship.
close it, right?
Much obliged.
Much obliged.
Yes, notice served.
Notice served, and last occasion, there is a
What is
service,
the violation? What is the last order?
last order of 5th of this month. Last occasion, they submitted that the incumbent has been transferred and new person has come. In that respect, this order was passed.
What is to be done?
This is with regard to present incumbent. But with regard to contemptor, contempt is made out, but as per this order, this has been submitted.
No, You are for petitioner?
Yeah. As per this chart, this is the development. The bank has intimated.
Who is not,
Mr. Tarak was appearing.
where is Mr. Tarak? Should not take, what is this?
This is after the order was passed. This is 11th of March. So this is with regard to present incumbent. He is not a party in this case. When I made a oral request to implement this party, and this order was passed. Compliance to this order, bank has taken the steps. With regard to contemner, reply has been filed, and from the reply itself, it is clear that the contempt is made out.
So what is this? Payment of terminal benefit?
What happened is during pendence of the
Has
case,
it been complied with or not?
not complied.
Huh?
Not complied.
What is this?
This
Why
is
you are
with-
showing this?
This is with regard to the last order passed by this Honorable Court.
Huh?
This is with regard to last order passed in respect
Which last order?
5th of
April,
March.
huh?
In respect to present incumbent.
So this means present incumbent means?
The contemner was the ex-chairman. In the meantime, he has been transferred. The new chairman has come.
By showing this, what do you want to?
This is with the order of this Honorable Court on 5th of March. To bank is to give some what step they have taken. This is the step they have taken.
So that has been it is an it is a
It is
compliance of
compliance
the
of
order.
the order of 5th March.
Huh?
Compliance of the order of the 5th March
Okay. Then
by the present chairman.
Hmm.
The contempt is the earlier chairman. He has filed a reply.
It's okay. Yeah. Ultimately, if it is compliant, what does it mean? Why we should go for technicalities?
No, the order
You
complies.
say this, whatever this, why you are showing this order to me?
This
To
is
this court.
This is with regard to 5th of March.
5th of March,
Yeah.
they have complied with.
Yeah.
Huh?
This is the order passed in the contempt application.
What
No.
is the order of 5th of the March? 5th of March.
Mr. Tarak shall on the next date fixed inevitably bring on record the steps taken by the bank authorities for compliance with the direction passed in order date so and so, so and so. After dismissal of the writ appeal being so and so. In the event instructions are not provided to the London Council, Mr. G. Tarak by the respondent, the present incumbent in the post of chairman of the Arunachal Pradesh Rural Bank shall remain present in this court on the next date fixed to answer the queries of the court and for further proceeding in the matter.
Yes.
This was the order.
So,
In this order, they have
see, on 5th of March, court has directed to bring on record the steps taken by the authorities. As per the order passed in
in
the,
the writ petition,
which is,
the
Which-
basis of the content.
yes.
But
So,
this is not-
thereafter they have passed the order.
This is not compliance in this true sense. They have only taken a step with regard to the present order. But compliance is not yet been done. Well, under what circumstances this order was passed?
So this is a step, one step to comply with the court's order. It's under process. What's there?
Since the order was passed, my honor, it is not that I placed this order to show that this is the status.
So its status is under process of compliance.
Let it be kept pending.
It's the willful disobedience. Maybe after the order of 5th of March, but then it's under process of compliance.
This by the present.
What has to be done today? You tell us.
No. I am not on that. I am on with regard to the contempt. What is the role of the contemner? Contemner of file a reply. My lordship is to consider the reply. The reply itself is clear that contempt is committed by him.
Forget about that. The essence is
order is to comply or not.
Comply
Not there on
So according to you, it's in the process of compliance.
Yes.
Then
that is how I requested this order. The matter
Mr. So-and-so,
matter may be
counsel for
pending.
the petitioner. None appears for the alleged contemner. The Mr. G. Burman. Boro, learned counsel for the petitioner by placing an order dated, where is this? Communication.
11th of
Communication dated 11/03/2024. Issued by the General Manager within bracket admin and OPS bracket close. What is this? Arunachal Pradesh Rural Bank Head Office, Nahanlagan, submits that after the order dated 05/03/2024, the respondent bank,
Present incumbent of the bank.
the present incumbent of the present general manager of the bank.
Chairman. It should have been chairman. It is issued by general manager. Direction was given to
General
chairman.
manager of the bank. Present general manager of the bank, Mr. J.R. Pait, who is not added as a party respondent in this contempt petition, has taken steps for compliance of this compliance order of this court dated 28/01/2022, passed in WPC 184/2019, which is the subject matter of the present proceedings. Please stop. Having considered the above, it appears that the respondent authorities are in the process of compliance of the order of this court, for which they have initiated any steps as reflected in the copy of the communication dated 11/03/2024, passed by this, placed by the learned counsel for the petitioner. List this matter after 4 weeks. All right. A copy of the communication shall be kept in record.
May I prefer specific date because
after 4 weeks, we'll see. We'll see after 4 weeks. You are coming from?
I am coming from Delhi.
Delhi. Then in that case, when? After 4 weeks? First week of April, May. Just give the number. Next.
12th of April.
Item number 28.
12th of
April.
No, after 4 weeks, not 12th of April.
I have some difficulties because first week of April I have some difficulties.
No. After 4 weeks. Somewhere last part of April or 1st of May. You just give the number.
Third of May.
Just think.
3rd of May.
Huh?
3rd of May.
23rd.
3rd
of May. 03/05. Yes.
28. In this case,
for the petition, non-appears for petition on call. Yeah. Thank you. Yours over.
Lordship for 28, Lordship.
28.
Lordship.
MS L. Hagelan, additional PP present. List after 4 weeks.
In this case, I am also.
I
am also for the petitioner. 28th.
28.
Yeah. I am for the petitioner. That is, I am making a submission. This is the case with regard
Mr. So-and-so, learned counsel, what is to be done today?
In this case, only thing is that a criminal case is pending for last more than 10 years. And witness was summoned 5 years back. Till date, witness has not come. And earlier, I approved this.
Record is there.
Lordship, no, Lordship, we have
Any
called for
private
action.
respondent?
Yes, Lordship,
No,
they have
private
implemented-
bank has been made as party. Bank is made as party on my prayer, and Mr.
Lordship,
Nicky Panging was appearing in the last occasion for the bank.
he prayed for file his Brakalat number, Lordship, on last occasion.
Whether that has been filed or not.
Last occasion, he made a submission.
Yes.
Accordingly, urgent.
LCR not received.
Lordship, not received. LCR as well as Lordship.
But
can
Mr.
copy
G.
of-
Ball,
Yeah.
learned counsel for the petitioner. You just delete all this. You just, and Mr. G. Ball,
Yeah.
learned counsel for the petitioner. MS so-and-so, L. Hagelan, additional PP present. Office note dated 22/3/2024 reflects that trial court records is yet to be received. List after 4 weeks.
Lordship, on the order dated 21/12, Lordship, we have called for the scan copy of the CD also, Lordship. Yes, Delhi. So it may be called for.
23rd.
21/12/2023, Lordship. Yeah, order dated, Lordship, here. We have called for the scan copy of the LCR or scan copy of the CD also, case diary.
It's okay. If it will include including that trial court record,
Lordship.
CD, why CD is required?
Lordship, in the order dated, Lordship, it is reflected there,
All
Lordship.
with those, is it not merged with along with all those charge sheet?
Lordship.
Only order sheets of court is required because to the date of admission, point was if there is a delay on the part of the trial, the 5 years time was given for a particular witness
for
is
the-
not turned up.
Call for the CD.
Scan
case
copy
diary.
of the case diary.
Huh?
Scan copy of the case diary,
LCR.
CD.
Lower court records, not CD is not required because it is to see whether delay is committed due to.
What is the order of calling the CD?
Lordship, on the order dated 21/12/2023,
Ah.
Lordship. 23, yes, Lordship. The first order, Lordship.
The yet to be received. This matter so and so before that. Before that. Yet to be received. As directed by this, as the scan copy of the trial court record be called along with the case diary from the court of CGM along
Lordship.
as directed by this court on 21/12/2023.
Obliged, Lordship.
What is the, suppose if you trial court record is called,
Lordship.
what is the question of CD?
Lordship, here, Lordship, this order was as if it is granted, Lordship.
Huh?
The Lordship, after,
Is it required to call for the CD?
Lordship, at
Along
that time,
with
Lordship, I was not there, Lordship. Other additional people was there. He called for,
according to
Lordship.
the procedure, as well as the requirement.
No. it is
Suppose if you call the court,
No,
trial court record,
it will
it
be
is necessary to say that the
trial court
CD
record
should-
will prove because of the lapses on the part of prosecution matter is not proceeding for last 5 years.
No, that's what I'm saying. The
So
nature of
lower
the
court record is
CD,
required. CD is not required.
why CD has to be called? I'm asking whether the CD
Yes,
is.
CD is to come to the merit of the case. This is not the case. My simple case is that this is a
Anyway.
case where prosecution is.
Yes.
Can it
Thank
can it be the same date, 3rd of May?
After 4 weeks.
No, a specific date along with that. 3rd of May.
3rd of May.
Obliged.
Obliged, Lordship.
Item number 29.
Necessary.
May I please, Your Lordship?
Hmm.
Lordship, I am appearing for the petitioner, my lord.
Yes.
I'm appearing
What is
on
to be
behalf
done
of
today?
Mr. Mukherjee.
Huh?
I'm appearing on behalf of Mr. Mukherjee, standing
Yes.
counsel for Guwahati High Court.
You are
In
supposed
this
to
case,
file the
we're supposed to
affidavit.
file the affidavit,
Huh?
but the affidavit is already sent to the principal bench for vetting, Your Honor. However, we have not received the vetted copy yet.
My lord may see their conduct, my lord. On if your lordships have a look at the orders, earlier orders, my lord, on 21st of 2024, last opportunity was given to the respondent to file their affidavit. Then also there also they have stated that it was at the stage of vetting. Then it was listed on 12/2/24. Then also there also they have said that it was sent for vetting. Next fixed on 5/3/2024. Yeah, that day also last chance was given to them. My lord, kindly see their conduct.
Yes, what right you have?
My lord, basically it's a transfer case, my lord.
It's
So
okay.
for-
What right you have?
My lord,
It is to be considered by the competent authority.
yes, but the authority is not considering, my lord. That is the
What,
difficulty.
what right has been violated by not transferring you? You have
My
sought for a transfer that
lord.
will be considered by the authority concerned.
My lord,
Has
yes.
it been rejected?
No, my lord.
Has it been rejected?
No, my lord. Till date, it has not been considered. That is the difficulty. And about my right, there is no notification regarding the transfer in the Arunachal Pradesh, my lord. But Guwahati High Court has issued some notification regarding the transfer in the subordinate courts in the state of Assam, but not in Arunachal Pradesh. That is the difficulty, my lord. That's why I have approached this honorable court. And my lord, if your lordships have a look at page 40.
It's okay. They want to file affidavit. Let them file. All right. Heard Mr. So-and-so learned counsel for the petitioner. Mr. MS
T.Y.
Bhutia, learned counsel appearing on behalf of Mr. M.
Mukherjee.
Pertin, learned senior standing counsel, Guwahati High Court. Press for and is granted 3 weeks time to file affidavit in opposition.
My lord, already 2 times, my lord, last chance was given, my lord.
It's okay. It's a transform policy that the competent authority will look into it. Why
My
you
lord-
have to file a retribution?
My lord, as my brother was the sole person to take care
It's
of.
okay. We understand that will be considered by the competent authority. Obviously, we are not saying that your case will not be considered, but it will be considered.
My lord, it's more than one. It's about to 1 year had been passed, my lord.
What is the indefeasible right that once you ask for request for a transfer, you should be transferred in a particular place which you have chosen? What is the right? What is your right?
My lord, as there was a vacant post, that's why I have chosen, and not I am not chosen.
That's what I'm saying. Is it your indefeasible right that wherever you choose, you will be transferred?
Definitely not, my lord.
Then it's
But
okay.
if I-
Thank you. After 3 weeks.
Item number 30.
Yes, MS Bhutia, tell your senior, I have seen your draft affidavit. You cannot be just like that. Just because you don't have the policy, you cannot transfer. That is not the case. Kindly look into it.
One of the
Draft
following
I have
is-
seen which you have placed in.
Yes, Your Honor.
You cannot, I mean, either you consider, accept it, I mean, consider and dispose of the representation. You just because that there is no policy as such, you just cannot keep it pending.
Your Honor, the affidavit was drafted on the basis of.
Because the
reply that we
petitioner has
received
sought
from
for
the-
transfer because his brother died.
Yes. Your Honor.
The hardship, I mean, that is to be considered sympathetically.
Your Honor, according
Not
to
just
the-
because there is no policy. If you don't have the policy for the state, yeah, that's good. Your the High Court policy will apply.
Yes, Your Honor. Then according
No,
to
it is
that,
subject to this. I mean, related to district judiciary.
yes, Your Honor. Then
That
according
big
to
affidavit
the,
will not help you.
according to the Assam policy,
Yes,
if in
you
case
have-
he is
you- that
transferred,
will be
he has
applied.
to go be the junior most staff.
Because
in the
this
place.
district judiciary is under the supervision of the High Court.
Yes,
If you don't have a specific policy for this state, you should apply for that. Just don't, I mean, that plea will not be accepted.
This is the affidavit that we received from the principal bench.
No,
It was
you have
filed
to,
by-
you are the standing counsel. You appraise your senior thing.
Yes, Your Honor.
Just because there is no policy, you just cannot keep it pending.
Yes.
That is what I wanted to convey to you.
Okay.
Yes, thank you. After 3 weeks.
Much obliged, my lord. Much obliged. A date may be fixed, my lord, if possible, my lord.
Huh?
If possible, a date may be fixed, my lord.
It's okay. After 3 weeks, we'll see. 30. Jaye.
Yes, yes, my lord.
You have not taken steps.
My lord, before leaving Guwahati,
Mr. So-and-so,
given-
learned counsel for the petitioner is permitted to take steps for service of notice upon respondent number?
so 1 and 2, yeah. my
1
lord.
and 2.
Yes.
You have not taken. Within 3 days, list this matter after 3 weeks. 4 weeks.
Obliged, my lord.
Item number 32.
32, say, 32 and 34, yes. 2 and 34. Item number 32 and item number 34.
30,
32 and 34. Yes, ma'am.
Item number 35.
whatever, 33? 33?
33. Item number 33. 33.
Adjourn. Okay. Then 34 over.
34 now.
34 over, and then now 35. Okay. Yes. Hmm. Yes, Daddy.
Yes, Your Lordship.
Huh?
We have not received the case diary, Your Lordship.
Non appears on for petition on call. TG learn additional PP. Has submitted that she has not received the case diary. List this matter after 4 weeks.
Deeply,
The call for the case diary.
deeply obliged.
Item number 39.
May it please your lordship.
Yes.
Lordship, in this matter, it is challenging the NIT, challenging the awarding of.
No, what is to be done today?
My lord, we had gone against the non-granting of a stay to the division bench, my lord.
Ah.
There was an order, my lord.
Yes.
My lord, it was to be considered for disposal if lordship is not otherwise inconvenienced.
And there's a private respondent whether the step has been completed or not, ma'am.
In this matter, I was the lowest bidder, but then they have made me L3 instead of L1. Mine was -5, but then they made L1.
Service report in respect of respondent 5 and 6 are still awaited. Will you wait for some time?
Mine.
When did you take the steps?
My lord, steps of the
13-2.
Then, my lord, if 1 month is over, my lord, it may be presumed, my lord.
No, in that case, we'll fix next week. We'll wait for some time.
My lord.
Or can you take fresh
Dusty.
steps? Dusty.
Dusty, listen. Can you serve?
So that we can take it up.
Yes, madam.
Is there any stay order?
Yes, my lord.
No,
there is no stay order, my lord.
There's no stay.
So that's why you are in a hurry.
I'm not.
They are not in a hurry.
They are not in a hurry, my lord.
So, Dusty.
Dusty, we'll try, my lord.
Heard Mr. Pidine, Learning Council for the petition. And also heard Mr. Titagum. You are for?
For Education Department, Standing Council for Education.
For Learning Standing Council for Education Department. Office note dated 22/3/2024 reflects that service report in respect of notice, the service of notice in respect of respondent service of notices in respect of respondent 5 and 6 are still awaited. It is noticed that the steps were taken on 13/02/2024. And the Same as the procedure was issued on 13/02/2024. In view of the learned counsel, the petitioner is permitted to take steps for service of notice upon respondent number 5 and 6 by Dusty Moth, which shall be rotated to the registry.
My lord, before the division bench, my lord, there was an undertaking given that they would file the official state respondents would file their.
We have already filed. It's
We
on
have
the
filed.
record. We have already filed. We have served a copy also.
Maybe they
Your-
did
your-
not.
the local council,
Anyway,
we have already filed. Served.
So when this should be listed?
My lord, if it is not inconvenience, my lord, on the 9th of April, my lord. if it
9th
is-
of April, I think it's a holiday here. I think, is it?
9th. From 11th is a holiday.
9th of April. Okay, 9th of April.
19th. Deeply obliged.
Your lordship, may it please, IA is for condoning a delay of 134 days. I pray a notice at this stage.
Notice to be issued. Notice to be issued. Huh?
Yes.
Or Mr. So-and-so learned counsel for the petitioner. This is an application under section 5 of limitation X, 1964. Praying for condoning of 134 days in filing the connected civil division petition. Mr. Issue notice returnable by 3 weeks. The learned counsel for the petitioner applicant shall take steps for service of notice upon the sole respondent by registered post within 3 days. Just after 3 weeks.
3 weeks.
3 days. 3 weeks, you take steps within 3 days.
Much obliged.
I don't know, 41.
'41, 2013. I appeared in this matter. The list this matter before any other appropriate bench without me. Within bracket me. 2013 matter. Can you see it?
Close.
But ultimately, I cannot. I can take up. I here the government council. 2013. Can you take note of it?
Close.
Your lordship, questions of awarding and not awarding the marks is the issue here. Yes, I've seen lordship, so for the question number 36 of GK. If lordship see this particular question.
Who is for the petitioner? Who is for the petitioner? See, proceed.
If lordship see the question number 33.
Yes.
Petitioner's lordship. Kindly come to page 32 lordship. 52 lordship.
According to her,
Lordship.
she marked the correct answer.
Correct.
And wrongly,
Mark
marks was not given. But the respondent 3 and 4, same question, it was given the marks as being correct answer. If these 2 marks are given, 2 questions are given to her, she stood on top of the 3 and 4.
Lordship.
That's the case.
Here lordship, if lordship see the.
In that case, we will allow, if that is the fact.
No, lordship kindly come.
And it shows your conduct that you have never, they refused to furnish the answer script. They had to approach the prisoner, had to approach the commission, then ultimately you have to furnish the
Law.
answer is true. What is your defense?
Kindly come to
You tell us your defense.
I'm coming to that only. Page 75.
75.
Page 75. If process see the page 75, okay?
Yes.
The
Yes.
question number 39 and 44 also. This is the answer.
75.
Page 75, question number 39 and lossy 44.
39.
39 and 44.
Where it is? 75 is something else.
Page 75 of the read petition.
75 of the writ petition.
Law.
Okay. Yes. 39 and
44 laws.
yes.
These two question laws.
Hmm.
The private respondent number 3 laws has given the right answer laws, but marks have not been given laws. Had it been given laws, the 4 marks would have been laws added to his total marks laws.
Two petitioner.
Private respondent.
Respondent, two private respondents.
Private respondent number 3 laws.
Though this was correct, but then no marks was
No
given.
marks.
Why?
This error laws on the part of the checker laws.
Then this
In case of the petitioner lawsuit, only one lawsuit in one lawsuit answer that was correct, but answer a mark was not given. That's a two mark lawsuit.
which one?
The question number lawsuit
39.
36 lawsuit.
Who is called the Napoleon of
Napoleon.
Pennsylvania.
Here lawsuit, this is the answer script of the private respondent number 3 lawsuit. Here lawsuit, question number 36 lawsuit. The right answer is Samudra Gupta lawsuit. Mark has been given, but in case of the petitioner, the same answer, but the mark was not given.
It
But
consists of two.
what I'm lawsuit trying to point out is lawsuit. Here also, in case of the private respondent number 3 also lawsuit. Two correct answer have been given, but marks were not given to him. Two right answer were lawsuit there in respect of the private respondent number 3 lawsuit. Question number 39 and 44 lawsuit. But the marks were not given to him.
This is annexed by
The petitioner only. This is the answer script of the respondent number 3 lawsuit. It starts from page 70.
Have you calculated?
Calculated it.
If it is the in respect of petitioner respondent.
Both of them secure 72 marks as per lawsuit. The answer marks given by the lawsuit checker lawsuit. Both of equally they have been given 72 marks. If 2 marks is added to petitioner's total loss, it comes to 74 losses. If 4 marks are added to the private respondent number 3, it comes to 46 losses.
76.
Sorry, 76.
Which is higher than that.
Higher than either way higher than the petitioner.
So according to you, by this page 75,
Losses.
so far as question number 39 and 44, though the
Correct answer has been given.
2 correct answer has been given by respondent number 3.
But
No marks were not given. 4 marks were not given.
4 marks were not.
And in respect of petitioner, only 2 marks were not given.
That's the on face of the lawsuit records, and it's also reply given in our academic lawsuit.
But she said something different. She said if 4 marks were added to him.
No, 2 marks.
4 marks.
One is lawsuit that lawsuit computer. I'm coming to computer question.
Okay.
Computer.
So this total, this is in respect of, this marks is in respect of?
Private respondent number 3 lawsuit. This is page, it starts from lawsuit 70 lawsuit.
This is.
This is of private respondent number 3.
No,
Mukesh
this starts from where?
Page 70 lawsuit.
70.
70.
This is Mukesh
Kumar Thakur.
Thakur,
Lordship.
72 out of
72.
100.
And
What about the petitioner?
petitioner Lordship,
Page
kindly come to Lordship petition now. Page 52 Lordship.
52.
Sorry, not 52 Lordship. It starts from page 47 Lordship. And kindly come to page 48 Lordship.
This way.
47, it starts from page 47.
$72.
Yes.
Nangamno.
Yes.
72. Huh?
Out of 172 has been given.
Ah,
On next page, 48 Lordship, on top Lordship 5.
72. Yes.
And other top.
This is in which subject?
Petitioner.
Which subject?
This is GK only.
GK.
GK.
GK, English and computer.
Computer.
English also.
English also.
So this is GK 72.
70
each.
Both of them also 72.
Oh, so far as respondent number 3 is concerned.
3 is concerned.
What
And
about
in GK Lordship for respondent number 4, GK is yes, no issue. No
No
issue
issue.
has been there.
Okay.
Only the computer Lordship.
So respondent number 3, correct answer 2, huh?
Lordship.
Question number 39 and 44. But no marks.
No marks.
Petitioner, question number 36.
Lordship.
Correct answer. Yes. Yes. Then
Then Lordship, this is then Lordship kindly come to page 90 Lordship.
90.
Lordship, 9090. If Lordship see the sorry.
Petitioner, who is appearing for the petitioner? Nobody appears. You find out next week, we'll take it up.
No, just can you see the Lordship page number 55?
Which 55?
Page 55, read petition Lordship. This is the mark, sorry, answer script of the petitioner, read petitioner Lordship.
What answer is skipped? Computer.
Lordship. Computer theory.
28. Out of?
Out of Lordship,
The dispute is for respondent number 3, it's with regard to GK paper and respondent number 4 computer.
and Lordship,
So-
if Lordship see this particular mark Lordship, page 55 Lordship.
Question
Page
number
50,
4.
Question number 4 Lordship. What the petitioner did is question number, can you see the post B? Suppose say
This cleanup.
This cleanup Lordship. What petitioner did is Lordship, first he tick mark Lordship, then on right hand side again Lordship cross mark Lordship. What he is supposed to do is Lordship, this tick mark itself should have been Lordship cross Lordship. So it amount to Lordship deviation from the instruction given in the Lordship very question Lordship. instruction is already given, lordship. If you are changing the lordship answer, lordship, then after tick mark, lordship, if you are changing the tick mark has to be lordship crossed again. As the same has been did in other lordship cases also. Because herself, question number 8, lordship, he did lordship.
In case you want to change the answer, you already tick mark. Put a cross against the earlier option.
Kindly
And
come
tick
to
the
question
new
number
option.
8, lordship, page 56, lordship. It's her own lordship. Question number 8, lordship, page 56. Question number 8, lordship. 8D, lordship. Video and audio, lordship. First, see tick mark and right mark, lordship. Then cross. It should have been done in this manner only.
You read the language.
Instruction 9 also, page 54.
In case you want to change the answer, already
Already
tick mark, put a cross.
Against the earlier option.
Earlier option, not that tick one.
Tick the new option. The tick the new option is put a new answer also.
Put a cross against the earlier option.
Earlier option.
Option means what? Answer, option of the answer,
Which
not
you have
the
already
not
marked.
tick one. You are saying that the first, if you give the tick mark,
Close it.
it has to be crossed there only. It's not that.
That has to be crossed
No.
again.
Once cross is more than enough. Against the earlier option. Say option is, say for example, this cleanup. You tick it, you only have to cross it, which he has done. Not necessarily in the tick portion. It talks about the option on the tick mark.
The tick is the correct loss.
Yes.
So whether this is correct or
Put a cross against earlier option.
earlier option. Like this
Option is the answer, not the tick one.
lordship here, lordship, it connotes two meaning, lordship. One is tick mark, other one is right, lordship.
Then
One
you,
is the tick mark and one is the cross.
you read serial number 6. Each question has 4 answer options. Out of which only option is correct. The answer. You want that once you tick it, if you change it, the cross has to be within that tick mark. That is what you are interpreting, not that. It says, it talks about the option only.
Lordship, the tick mark, lordship, until unless that is ultra lordship, that very tick mark.
Tick mark and then you have to put cross.
Lordship, that has
Which she has done.
No, she has not done over the lordship tick mark, lordship.
That's what I'm saying. It is not over the tick mark. It's the only the option. You read it. Serial number 9 again.
In case you want to change the answer already tick mark, put a cross against the
Earlier option, not the tick mark.
But our interpretation.
And tick the new option. Your interpretation is wrong.
But
as per your the instruction.
But our
your instruction, matlab, the authority.
No, that I understood.
Not you.
That I understood. Lordship. But in our lordship, affidavit lordship, we have clearly stated lordship. The over the tick mark, it has to be crossed, lordship.
I may agree with the GK, but here we don't agree. You have to put cross mark only if you want to change the option, which he has done. Question number 4. First tick mark, then cross.
This is lordship, our interpretation lordship.
Okay, so in that case, suppose if you held that this is correct, then C scores higher than the respondent number 4, right?
No. Even if this is treated to be correct also, then lordship, at least private respondent number 3 lordship.
No, you have appointed how many? Where is the advertisement?
What is mean?
No, that's why I just don't want to adjourn the matter, but then you come prepare on look and since the petitioner is not there, we'll take it up on next week,
Close it.
Monday, since 2000.
Close it. Actually, otherwise also Lord, it was being.
Who is being who appeared for the petition? You are for? You have been appointed, huh?
No, no.
As a the respondent.
Indeed,
And respondent number 4, you both are appearing for Esquire. He's appearing for 3 and 4.
Only 3.
Okay.
I think they have been already appointed Lordship. This result notification is of 2nd January 2017. And from the general pool Lordship, 3 candidates were selected and the petition was kept in the waiting list Lordship and merit at serial number 1 and 2 Lordship. Those are the private respondents Lordship.
What is the result notification?
It's at page 26 Lordship.
26.
26.
The total marks obtained by them is who is respondent number 4? Mukesh Kumar Thakur is 253 and half.
Pallab Gogoi is the
Pallab Gogoi, 258. This is his respondent number 4.
4.
Suppose if he's added, two 254. So if 4 marks are added to respondent number 3 and 2 marks are added to respondent petitioner, still then respondent 3 is above. Respondent number 4, even if 2 marks is added, it will be 251 and half, 252 half. Because respondent 4 has got 258. Only the respondent in between respondent 1 and 3 and petitioner.
This is it.
So if we agree that 4 has to be added and another 2 has to be added, is still then he's
Yes.
above
That
petitioner.
is the actual position.
And in the computer, even if it's added in respect of in computer, she cannot much ahead of respondent number 4 because he has got 250.
Much higher. And I have seen the record Lordship regarding the question number Lordship 13 and 14 Lordship.
Yes.
computer application. From petitioner side, there was a lawsuit, objection lawsuit. The answer given by the private respondent number 4 lawsuit is not correct lawsuit. Then we have already filed our additional affidavit and bringing in the lawsuit answer sheet lawsuit. Where lawsuit.
There's the allegation that
This is not the correct answer lawsuit.
Okay.
This answer sheet we have lawsuit annex, and as per answer sheet lawsuit is found to be correct.
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 So some answers which you have given marks to the respondent 3 and 4. According to him, it's not correct answer. To that you have clarified.
We did, apart from those marks lawsuit, 2 questions regarding question number 13 and 14.
That may be the reason that the petitioner may not be interested. Right? You appraise that who is the counsel for the thing? They might have calculated it, even if agreed that these marks are added. Still then she cannot march above them. Maybe that could be the reason they are not appearing. Heard Mr. Estafin Lara, senior country, the leader, senior government advocate, or the respondent, state respondent. Also heard Mr. T. Pine, so and so. For respondent number 3 and 4. 3. 4. 3.
They are
okay.
together.
Non-appeals for respondent number 4. Before that, you just write non-appeals for the petitioner on call, huh? List this matter on Monday. We'll take it up on Monday. On not Monday, second Tuesday. Monday is first.
Lawsuit after a week, lawsuit. Actually,
after a week, what?
Next Friday. Because
Friday. No, we're not giving.
Because
we just wanted to hear them. I have heard the respondent. You may not be required also. We'll hear the petitioner and decide the matter. There's nothing. Then in that case, somewhere in the Thursday. Thursday is a holiday or what? Make it in 10th. 1004. 2024, huh? The learned senior government advocate is requested to inform the learned counsel for the petition. If they are not interested, we will close it down.
Close.
Maybe they have calculated it. Even if 4 marks are added, she may not get, that's why. Yes. Next, it's okay. What is the last matter we'll see?
I think 43.
43 adjourn.
Thank you.
43 adjourn, I think. Nobody. 43 they made a mention. I think after 2 weeks something. 44 you call up 44.
The matter is waiting for another.
Can I take up this matter?
No, matter they wanted to file a rejoinder despite matters.
No, can I take up this matter? In division bench?
Yes.
But then matter is very simple now. You are giving a preferential treatment. You are giving a good rented house, right? Private rented house to some of the people, and you are not giving them. That is the issue now.
In the other case, those people who have been given rent for 1 month, that's why the corporation, given by the corporation, because they will not be getting quarter. But in their case, they will be getting quarter after construction of the building. That's the difference. And they have been given alternate accommodation also.
Anyway.
Leading counsel, he is joining in virtual mode.
I appear for the petitioner, my lords.
Yes.
My lord had rightly pointed out, my lord.
No, it's okay. What is to be done today? Should we dispose it of
Please, my lord. I would request, my lord. I would request, my lord.
See, Learned Standing Council said that you would like to file
Rejoinder.
rejoinder.
No, no, my lord.
Who-
We had already waived off our right to file a rejoinder, my lord, on last occasion. Now, I would request my lord to dispose it off. It's already been a long time, my lord. The matter is been here, then the Supreme Court, then back here, my lord.
who has taken for respond number 3?
Yeah.
You want to file rejoinder?
No, no, my lord. No rejoinder. No rejoinder. We had waived off our right on the last occasion. We had orally informed the court that we do not wish to file the rejoinder. Maybe fixed up for final hearing, my lord.
We'll see at 2. At 2 we'll see.
Please.
Lordship has correctly pointed out, Lordship already, this matter, in other cases, similar facts, Lordship is already.
So I cannot take it up.
There definitely there's some bearing, because already matters.
Yes, the Learned Standing Council objecting that it's just apprising that this court may not take up this matter. I have dealt with the same matter while sitting in the division bench. What do you say?
My lord, I have no problems in my lord adjudicating this matter, my lord.
No,
Let-
if
let it
other
be on
party,
record.
no,
Please.
other party object, then I may not like to take it.
My
Take
my
it
lord,
up.
the facts of this matter are very peculiar, very limited to the fact.
No, I have seen it.
Please,
But then
please.
once there is an objection, we'll have to
Please.
consider that also.
Please. I bow down to whatever my lord decides. for
Because
me.
I have indicated writ petition will be allowed. So there is a objection. Yes, Mr. Thapo. I have indicated them writ petition will be allowed. So he has now he has an objection.
No, not because of this.
List this matter before any other appropriate bench without. Take it up any other bench.
Lordship, kindly fix that he's from.
I cannot take if I cannot take it up. Huh? Huh? Okay. Is there?
Yeah.
What is that there? We'll take it up to.
I beg your pardon, my lord.
Item 43.
No, my lord, I beg your pardon. Since the time of mention, my lord, this morning I could not reach on time. So I'm seeking permission to mention one unlisted matter since there is an urgency.
No.
AP. My lord,
They
from
will
tomorrow-
let it tomorrow.
From tomorrow, the applicant is having the exams. My lord.
Huh?
And she is doing the BEd, so she is having the exam from tomorrow. We have
Tomorrow, what?
Yes, my lord.
This is for what?
It's a pre-arrest bail. my lord.
Tomorrow he is
Yes.
having an exam.
Exam, yes, my lord. Tomorrow and day after tomorrow, she's having the exam. So
we'll see.
I know
Your
it's not the
Lordship,
procedure.
Your Lordship, in item number 43, the council is not present. Your Lordship, it could pass this matter after 2 weeks, Your Lordship.
No, 43, somebody made the mention. I have ticked it, somebody made a mention. You checked it out. If not, list after 4 weeks.
Oh, yes.
Huh? If there is no any order in item 43, find it out, list after then 2 weeks or 3 weeks.
3 weeks, Your Lordship.
3 weeks. Nobody is there.
Nobody is there.
None appears for the petitioner. On call, MST in Learned additional PP present. List this matter after 3 weeks.
3 weeks.
My lord, may we kindly take it up today?
Take him for surgery.
Surgery, where you are seeking?
We will see at Assam Medical College, which is near Monsa.
No, you have been taken there, but then this.
But they are not carrying on the surgery part because doctor had suggested for surgery. He is suffering from kidney stone, which is a severe pain. So kidney stone, the most severest pain ever human can have. So he has to live with pain. The order was issued on 7th of March, the medical board report.
What is to be done?